For motion item number 1,
Please, I will also say additional benefit with attachment liabilities. Bank statement.
Certificate which is at page 99. There's no date.
That is convention.
If you are receiving 8,500, where is any deposit of 8,500 in your bank account?
They did not pay in the bank account.
Then how are you maintaining this bank account if you have only 8,500? How are you maintaining? How there is inflow of cash or how there is inflow of anything? Then should we put this person behind jail for falsifying affidavits before this court?
Transaction is there.
Is it a case of 340
Oh my
under the CRPC? Absolutely. On one hand, should we call this owner, the owner of this Kolposity Borua, who has given an affidavit, a year of remuneration certificate, no date, nothing mentioned.
Ask
Huh?
them to give a
And there is not a
certificate and
single
please-
deposit of that. Whereas there are deposits of 20,000. 25,998. How are you maintaining this? Tell me.
Balance transfer, I think.
Yeah. How are you having the balance? How are you having the total credit?
An employee of this AK Enterprises, and some people gave him this was balance amount or this.
Hello, we do one thing, we'll only issue notice, nothing more. Okay. The notice making it returnable on 2nd of August 2024. Steps be taken by way of registered as well as usual upon the sole respondent.
High level is
Petitions, item number 2.
We need 2 weeks time to file affidavit.
Who is paying for 6 and 7?
Okay. We have taken steps. We have
I
taken
also,
steps.
my lord, so this still also, my lord, was taken steps. So as for the last product, your lordship asked me to, my lord, for the history, my lord.
Okay, the service is otherwise complete. Now, what do you want to do?
File
From the perusal of the materials on record, it reveals that the respondent numbers 4 and 5 has filed an affidavit in opposition, 6/6/2024. The learned counsel appearing on behalf of the petitioner by some time for filing a reply. Accordingly, 3 weeks' time is granted to do so. This the matter again on 19th of July 2024. Same order passed earlier shall continue. The court also further takes note of that the service upon the respondent number 6 and 7 complete in view of the notice contained in view of the orders so passed by the learned lords in the court. In addition to that, the learned counsel appearing on behalf of the learned counsel, Mr. T. Mahanta, the learned senior counsel, Mr. T.J. Mahanta, appearing on behalf of the respondent number 5, had also submitted that due steps have been taken. Is the court. Yes.
Lordship, there is a concurrent findings of the line court below, lordship, the first appellate court and as well as the trial court, lordship. Regarding, only the.
What are the substantial
Yes, sir.
questions
Yes,
of
sir.
law?
Page number 4, lordship. 4.
Huh?
Page 4 are the substantial questions.
8-4. Wait. I'm going level from food by this again. Got it.
Yes,
Whether the quotes below were justified to decree the suit on presumption that the layer was in prior to filing of the suit.
basic, yes.
Whether they were justified to decree the suit, think that the plaintiff had duly. Yes, now tell me,
I think the basic issue is that lordship, this appellant,
you are the plaintiff.
I was the defendant lordship.
Yeah.
The plaintiff is the lordship that who lordship claimed that he purchased the land scheduled lordship the disputed land in the year 2005. If that lordship of this appellant and the defendant are respondent number 1, respondent number 2, they are lordship brothers. They have their ancestral property measuring lordship 2 bighas, 2 bighas, 2 quota, 12 acres of land. So under lordship, on mutual understanding, they were occupying the said land by sharing 50-50 lordship without any formal partition and amicable settlement. Just they are just occupying the land in lordship in horizontal basis, northern and southern portion. This appellant has been occupying the land of northern portion, and this petitioner, the respondent, defendant, respondent 2, he was in the southern side. So lordship, in the year 2005, the respondent number 2, he lordship sold out his portion of land.
How much is the land?
1 bigha, 2 quota, 6 acres of land.
1 bigha,
2 quota, 6 acres of land.
total land was 1 bigha,
Total land was 2 bigha.
Huh?
Total land 2 bigha,
2 bighas,
4 kathas,
4 katha,
12 acres.
12 acres. And half is 1 bigha, 2 katha, 6 acres. So each person was entitled to this.
Yes.
Okay, then,
Then lordship, the land was lordship there in the western side.
so you admit the sale by the defendant respondent number 2 to the plaintiff,
It was not the knowledge of this land.
whatever may
Yes.
be, there is a sale.
He has denied lordship.
Who has denied?
He has denied that that portion of land has been sold out.
I'm not concerned. Whether the respondent number 2 defendant number 2 has sold that portion of the land to the plaintiff.
Yes, lordship. As per the sale date, it is there.
Yes. So that is done. So how much?
For first 2 sale deed was there. In the first sale deed, lordship, he has sold out 3 quotas of land, and by the second lordship sale deed, he has sold out 4 quotas, 6 acres of land. The entire land lordship.
So this 1 bigha, 2 katha, 6 acres was sold by the defendant number 2 to the plaintiff.
Lordship.
Okay. By 2 sale deeds.
2 sale.
Then
Then lordship, the land as stated by the plaintiff that he has purchased the land from defendant number 2 is not the land lordship which was in
there is boundaries in the sale deed.
boundaries in the sale deed. Lordship will find the first lordship will find page 19. They have given a lordship site plan. Their contention is that lordship, this land was divided in horizontal basis, and our defense was that lordship, it was in vertical basis. Accordingly, we were on the lordship northern side, and this defendant was in the southern side. Now, if lordship see the schedule they have mentioned, that the lordship will find a difference in the boundaries also. And one thing, lordship, I want to break to lordship to kind attention is that prior to filing this suit, they have filed another suit in 2007, and that was also subsequently withdrawn with liberty to file. In the said plain lordship, their defense was their prayer was also lordship different, which is not similar to the prayer.
No concern. Liberty has been given.
Liberty was given, but lordship, what has they have stated in the first play, that cannot be denied because it was on court, and all court has admitted that plain also. They have withdrawn it with liberty, that is issue with their lordship. Accordingly, they have filed a subsequent suit.
Okay, let us further proceed.
Lordship,
Yes.
find at page 17. The schedule of the land lordship. Schedule 1 land lordship. All that part and parcel of revenue paying land measuring 2 bigha 4 kotha 12 places of land.
Mr. Counsel, if you are going to go into that schedule, I will just say
No,
it
no,
is a
sir, only
dispute,
the
it is
prima
a
facie
question
difference,
of
sir.
fact.
No, no, only
does
the
not
prima
arise.
facie difference. Prima facie difference, not going to the deep of the procedure, just prima facie difference. They have explained 3 lawsuit schedule. The one, schedule 1 and 2 is divided into schedule 2A and 2B. If lawsuit go by the schedule 2A and 2B, lawsuit will find the difference of their boundaries. Lawsuit will see the schedule B, 2 and small a.
Understood. Now
Yes.
finally come to the point.
Yes,
He has asked for declaration of his right title and interest
yes.
and recovery of possession or
Possession, yes,
confirmation.
yes. But our contention
Is it recovery of possession or confirmation of possession?
recovery of possession.
Okay.
So-
Now what has happened?
Now lawsuit, our
The
contention-
defendant number 2,
Yes.
did he file written statement?
Defendant number 2 file, defendant number 2 lawsuit, he did not file a written statement. Only
Huh?
this appellant filed a written statement. Only
Did he accept the claim of the plaintiff?
he lawsuit, the defendant number 2 was made as pro forma defendant.
Did he
Yes,
accept-
he has adduced in favor of the plaintiff.
So he has accepted the claim of the plaintiff.
Yes,
Now, the court has, yes, Mr. Khatunia, you remember one judgment I delivered? You were there on one side, the other side, Mr. P.K. Goswami was there on that matter pertaining to some provincialization.
It's a Nirupoma Borong, my lord.
You have, has it been reported?
Uh,
Nirupoma Buru.
I have the soft copy. I can check it out.
Yes,
ma'am.
I wanted actually there in that judgment I dealt with the question of notification.
Yes, my lord.
Yes, so you can give it to her,
Yes.
please. Yes.
yes. Lawsuit,
Now come to the point.
Yes.
So the trial court decreed the suit in favor of the plaintiff. The first appellate court also did.
alhamdulillah.
So there is a concurrent finding of fact.
Lawsuit.
Then what remains?
Remains is that lawsuit, both the trial court as well the first appellate court committed gave error, presuming that this plaintiff was in possession of the land prior to lawsuit issuing the suit. Now, although lawsuit there was to sell registered sale, but this plaintiff never took possession of the, he did not even lawsuit step into the disputed land. There was no possession was handed over to the plaintiff. This is the issue. lawsuit.
But are you in possession of the entire 2 bighas,
No,
4
no.
katha,
I
12
am
lakhs?
on my part. Only
The remaining is vacant.
remaining was lawsuit. Earlier, the defendant number 2 was there. So,
Then
so question is lawsuit regarding
what happened to the remaining land?
only issue is that lawsuit. Now the issue is that they are claiming that land was lawsuit partitioned in horizontal basis, and our claim is that land was in horizontal basis, and they claiming that the land was divided naturally but vertical basis. Wherein lawsuit, the
And the
plaintiff
2 courts have accepted that.
accepted that on presumption, no lawsuit evidence adduced by to that effect lawsuit.
They must have stated some evidence is given.
Some evidence of on presumption lawsuit.
Why will the court otherwise come up and say that,
Lawsuit-
yes, this is it?
Yes, lawsuit will find the findings of the trial court
Yes, let us
at
come
page 55 lawsuit
see the issues.
issues. Critical lawsuit vital issues regarding this. Whether the plaintiff was in possession of the Schedule 2 land. Now, one more question will come lawsuit. In this issue lawsuit, court has tried to lawsuit adjudicate all the Schedule 2 land. When the disputed land is lawsuit only in
There is
Schedule
a cause
2.
of action whether in the year 19. If acquired any. So 3 and issue number 5 is relevant. Into What does the registered sale deed say?
Registered shall deed lordship, registered shall deed lordship, that is.
What is the boundary of the registered sale deeds?
Boundary of the registered shall deed lordship, they have
Is
not
it as
mentioned,
per the suit?
they have not mentioned this plain.
Is it based upon the suit?
Lordship, they have not mentioned the plain regarding the sale deed. Just mentioned that they have purchased the land, but nothing else.
Hurry. The sale deeds were brought in. They were exhibited documents.
They have exhibited.
Well-
Sale deed is exhibited.
Now, what is the boundaries of the sale deed?
Sale deed boundary lordship, sale deed boundary is not matching with the boundary mentioned in the plain.
In the plain.
Plain
Where?
boundary is lordship will find a complete defined boundary and the prayer also defined lordship.
Yes, Mr. Mazumdar, the sale deeds boundary is different from the schedule 2A and 2B.
Same. It was, his stand is, in the sale deed, the boundary given could not have been given because according to them, the partition between the two brothers
Did not happen.
did not happen. They are affirming that
That is okay,
Ah.
but whether the perusal of the sale deed,
same. Well,
boundaries are same with the sale deed.
same, but they are
Do you have
saying
a copy of the sale deeds?
they have not raised this with you. What they are saying is,
It's okay.
yes,
No, because then the question comes,
yes,
if the boundaries are the same,
my lord. Boundary is same. That is
then,
why,
then in that case, without a challenge to the sale deed, they cannot succeed.
exactly, my lord. They have not
That is
challenged the
why
sale
I'm
deed.
saying.
In the prosecution here, it was, question was put, whether you have challenged the sale deed, whether you filed a counterclaim, they said no. I don't,
Therefore, my specific question to you.
yes,
Otherwise, it is a question of fact. Both the courts have come to a categorical fact on the basis of the evidence.
yes.
Evidence of PW2, PW3, PW4.
PW2 is the lordship mother-in-law of the plaintiff.
So what?
So lordship,
Mother-in-law,
they are
daughter-in-law, but
they
he
are
sees on the
particular
boundary.
yes.
But she is in the boundary.
But her statement has to be considered lordship. What he has
But
stated.
he is in the boundary.
He is the lordship neighbor of the suit land. That is fine. That's we have admitted. But what he have stated, definitely in favor of his son-in-law. And lordship, the question is lordship, what he has stated prior to in 2007 suit and 2008 suit are different lordship. In the 2007 suit, he has stated that he was dispossessed from the suit land lordship.
In the 2007 suit, you said that there was a partition.
There was a
In the
lordship. not for years.
2008 suit, you
No,
said
but
that there is
there
no
was-
partition.
Stated that there was a amicable settlement, not partition, that we were occupying the northern and southern portion.
So isn't that a partition?
Partition and
Isn't
lordship,
that
no,
amount to a family partition?
partition and settlement, what I have understood is a different issue, different lordship connotation. Because the partition lordship and settlement, we may settle with my colleague that yes, for the time being, you occupy this person and I will occupy this person. That is lordship settlement. And partition has to be lordship, either lordship oral or lordship in usual process that happen in the rural area. So there must be something written lordship in partition.
Huh?
Or oral maybe yes. Partition lordship to confirm that yes.
Kindly don't change the basic idea which I have of partition or settlement also. Law seems to be clear on that. You have it, Mr. Mazumdar?
And schedule also different lordship. They have mentioned is also different.
in the cross-examination method, he clearly admits that Ratneswar sold his share of the land. My vendor sold his share of the land to me.
Now, here in the sale deed, I'm not getting the schedule. The second sale deed is 2A.
There are two sales, one is of 1985.
Second sale deed is
2005 was.
2005.
11,2005.
2005 one, the north is Bikrita Mati, that is north is seller. Okin Bulu Soikia. East. Ipali. Yes. Then boundary is same 2A. You have not challenged the sale deeds.
And my lord, in the cross-examination,
Lordship will see the first page 12, Lordship.
What?
Which portion of land, Lordship? What is the disputed land in this suit, Lordship? The first they have to show that this is the disputed land. They have not specifically, Lordship, listed in their plain that this is the disputed land.
Mr. Counsel, this lifetime I don't have the opportunity to be a trial court judge any further.
But apparently, Lordship,
Next lifetime I may be a trial
Lordship,
court judge,
right.
then you may explain this one, not this one. This is not going to work out here in a second appeal.
Okay.
Okay, let me dictate. What?
The next week, Lordship, I will satisfy regarding the boundary of the cell deed. Boundary of the cell
Too
deed,
much
Lordship.
of time on this.
So, Lordship, see the page 17.
What page
Page
17?
17 is schedule.
No, nothing.
Which schedule,
Are
Lordship,
they-
the disputed land.
the last line, this is cross-examination. He admits that my vendor has sold his share of land to me. That is this.
That I won't much deal into because in a cross-examination, sometimes a person they may not understand. These type of things happen, but for that I should not on an order 11 rule 11 finish it off. But
Basically,
on the other way, you have no case.
ego clash, my lord.
Aye.
Ego. I have purchased, sale it is not challenged.
How this petitioner,
He
how
says,
this
no,
applicant
not
invest and
east,
access to
west,
his
west.
land. That is the issue.
Okay, give your name. Or Mr.
Take one, sir.
And so the learned counsel, if you take with the learned, Jay
Take one,
Kulta,
sir. Take one.
learned counsel appearing on behalf of the appellant and Mr. P. Mojumdar appearing on behalf of the respondent. Respondent,
One man.
here also you have make them performer. Your sole enemy, your brother.
Lordship,
Yes, he is the main cause of concern.
in his judgment, Lordship, they are never reflected, Lordship, so they will not.
He has sold the land
Right.
and then also you have made him a performer.
in a claim, in a,
No. The instant appeal is being taken up. The instant appeal under section 100 of the Code of Criminal Civil Procedure 1908, for short the CPC, is directed against the judgment and plea dated 3/8/2023 passed by the learned of the civil judge Dorong in title appeal number 1/2022, whereby the appeal filed by the appellant herein was dismissed, thereby affirming the judgment and decree dated 13/12/2021 passed by the learned civil judge, Junior Division number 2, although Dorong in title suit number 56/2013. The instant appeal is being taken up at the stage of Order 41, Rule 11, to consider as to whether any substantial question of law can be formulated in terms with section 100(4) of the code. आपके CPC कौन थे code को? For ascertaining as to whether the substantial questions of law so proposed by the appellant formulated, this court finds it relevant to take note briefly the facts involved which have led to the filing of the instant appeal. For the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. The respondent number 1 herein, as plaintiff, had instituted a suit taking declaration of his right, title, and interest in respect to the land described specifically in Schedule Roman 2 of the plain, semicolon, a decree for recovery of past possession from the defendant number 1, who is the appellant herein, a decree for permanent injunction restraining the defendant number 1 from dispossessing the plaintiff from the suit land if a decree for recovery of possession is passed in future, and for other reliefs. The edifice on the basis of which the suit was filed was that the defendant number 1 and defendant number 2, who is the performer? Defendant number 4. Okay. Edifice of the suit was filed. Is that the defendant number, the defendant, that the predecessor in interest of the defendant number 1 and 2, along with the performer defendant number 4, were joint owners of a plot of land which have been specifically described in Schedule Roman 1 of the plaintiff. The said land measures 2 bighas, 4 kata, 12 lechas, and is covered by dag numbers 181, dag number 181 of KP Patta number 139, situated at village Khas Punapur in the district of Dorong, Assam, and is specifically bounded by boundaries stated therein. It was the case of the plaintiff that in the year 1980, there was an amicable partition between the predecessor in interest of the defendant numbers 1 and 2 with the performer defendant number 4, and the suit land, which have been more specifically described in Schedule 2, fell into the share of the performer defendant number 4. Thereupon, in the year 2005, by the registered deed of sale, the performer defendant number 4 transferred the land which have been specifically described in Schedule Roman 2, Roman A, small a, to the plaintiff by the registered deed of sale
Document number 2
dated 12/8/2005. Subsequent thereto, by another deed of sale dated 3/11/2005, the performer defendant number 4 transferred another plot of land measuring 4 kathas 6 lechas to the defendant plaintiff It is also specifically mentioned that after purchasing the plots of land, the plaintiff was possessing the suit land without any objection, let, or hindrance from the defendant number 1. However, on 26/2/2007, the defendant number 1 dispossessed the plaintiff from the suit land. And it is under such circumstances the plaintiff filed a suit being title suit number 11/2007 before the court of the had filed a suit being title suit number 11/2007. However, on account of formal defects, the said suit was withdrawn with liberty to file a fresh suit. It is under such circumstances the suit was filed, which was registered and numbered, seeking the relief which, as aforestated, which was registered and numbered as title suit number 56/2013. The defendant number 1 participated in the said trial by filing a written statement. In paragraph number 2 of the said written statement, it was the specific contention of the defendant number 1 that the disputed bag is yet to be partitioned between the defendant number 1 and the performer defendant number 4. It was mentioned that the description of the suit land was wrong. It was, however, mentioned in paragraph number 8 that in the year 1980, the performer defendant number, the predecessor of the defendant numbers 1 and 2, and the performer defendant number 1 had amicably partitioned in paragraph number 8, it was denied that in the year 1980, the predecessor of the performer defendant, predecessor of the defendant number 1 and 2, along with the performer defendant number 4, had amicably partitioned the Schedule 1 land by way of family settlement. And the portion of land which was specifically described in Schedule 2 to the plain fell into the share of the performer defendant number 2. It was denied that on 26/2/2007, the defendant number 1 had dispossessed the plaintiff from the suit land. Rather, it was stated that the plaintiff did not have his feet on the suit land. In paragraph number 20 of the written statement, it was, however, stated that the suit land was not formally partitioned. However, the plaintiffs have, the defendant number one was possessing the northern half of the suit land and gave specific boundaries to that effect. On the basis of the said pleadings, as many as 7 issues were framed by the learned trial court. Issue number Roman 3 pertained to as to whether in the year 1980, the pro forma defendant number 2 and the defendant number 1 amicably partitioned the Schedule 1 land in equal shares by way of family arrangement, and if so, whether the Schedule 2 land fell in the share of the pro forma defendant number 2, who possessed it since then as its exclusive owner. Issue number Roman 5 was whether the plaintiff acquired any valid right, title, and interest over the Schedule 2 land by way of purchase from the pro forma defendant number 2 by 2 registered deeds of sale bearing deeds of sale dated 12/8/2005 and 3/11/2005, respectively. Issue number 6 was whether the plaintiff was in possession of Schedule Roman 2 land since the date of its purchase and whether he was dispossessed therefrom on 26/2/2007 by the defendant number 1. The learned trial court, by its judgment and decree dated 13th of December 2021, decreed the suit in favor of the plaintiff. In doing so, the learned trial court decided the issue number 3 in favor of the plaintiff. After taking into account the evidence which have been adduced by the plaintiff's witnesses, and also taking into account that there was an admission by the defendant number 1 in the earlier suit proceedings as regards the partition of the suit land amongst the predecessor in interest of the defendant number 1 and 2 with the pro forma defendant number 2. While deciding the issue number 5, the learned trial court also decided the same in favor of the plaintiff, and more particularly taking into account the deeds of sale which were duly exhibited as exhibits 2 and 3 respectively by the plaintiff. While deciding the issue number 6, the learned trial court also decided in favor of the plaintiff. That the plaintiff was in possession of the suit land pursuant to was in possession of the Schedule Roman 2 land since the date of the purchase, and the plaintiff was dispossessed by the defendant number 1 on 26/2/2007. The defendant number one being aggrieved by the judgment and decree dated 13/12/2021, filed an appeal being titled Appeal number 1/2022 before the Court of the Civil Judge Dorong. The learned First Appellate Court had decided the share issues, said appeal issue-wise, and affirmed the judgment of the learned trial court. It is against that the instant appeal has been preferred. This court have duly heard the learned counsel appearing on behalf of the petitioner, appellant, who proposed two substantial questions of law, which, as per him, can be formulated in the instant appeal. Mr. D. Majumdar, the learned senior counsel, assisted by Mr. S. Biswas, submitted that those substantial questions of law, so submitted, under no circumstances can be said to be substantial questions of law. The learned senior counsel submitted that these are purely questions of facts and does not touch on the question of perversity, for which it under such circumstances, the question of framing any substantial question of law under section 100 of the code, 100(4) of the code does not arise. This court had given anxious consideration to the respective submissions and would hereinafter analyze as to whether the questions of law so submitted, proposed by the learned counsel appearing on behalf of the appellant, can at all be formulated as substantial questions of law involved substantial questions of law. The first the question of law which have been formulated, proposed, is as to whether both the learned courts below were justified in decreeing the suit on presumption that the plaintiff / the respondent number one was in possession of the suit land prior to filing of the suit. This court have duly taken note of the judgments passed by both the courts below. From a perusal of the said judgments, the learned trial court, as well as the learned first appellate court, have duly taken note of the evidence, and on the basis thereof had arrived at a finding of fact that the plaintiff was in possession of the suit land as described in Schedule Roman 2, pursuant to purchase. This being purely a question of fact, in the opinion of this court, cannot be said to be a substantial question of law involved. And cannot be said to be a question of law. And more so, a substantial question of law involved. Next. The next question of law which have been proposed is as to whether the learned courts below were justified in decreeing the suit, holding that the plaintiff had duly executed the sale deed which confers exclusive right, title, and interest over the suit land without considering the possession and right to sale of the seller of the said land. The said question of law, in the opinion of this court, cannot be said to be a substantial question of law, inasmuch as there is no challenge to the deeds of sale. This court have also duly taken note of that the deeds of sale specifically describe the boundaries which are same with the boundaries as described in Schedule Roman 2A and Roman 2B. Without a challenge to the said sale deed, the plaintiff cannot raise this question. This court also finds it relevant to observe that by virtue of Section 44 of the Transfer of Property Act 1882, a co-owner would be authorized and competent to sell his portion of the land. There is, however, no quarrel with the fact that the defendant number 4, defendant number 4, performer and defendant number 4, 2 is
It
his.
should be 2 also. Earlier also Lordship was stated in 2, 4, but it should be 2.
Huh?
And number preferred defendant number 2. He has sold out the land.
Before defendant number 2 had sold out the land, who was duly competent to do so. Under such circumstances, the question of law so proposed cannot, in the opinion of this court, be a substantial question of law involved. It cannot be a substantial question of law which can be formulated in terms with Section 100(4) of the Code. Considering the above, as there is no substantial question of law which can be formulated, this court finds no merit in the instant appeal, for which the appeal stands dismissed with cost quantified now. So in taking into account the stage at which the instant appeal is being dismissed, this court is not inclined to impose any cost.
There's some paragraph Lordship was stated as preferred number 4, it should be 2 also. Obliged.
So you didn't have your luck for 2 weeks to put this matter before me. The sad part of it.
Right.
Enough 4. Yes.
Lord, we have preferred the second appeal, challenging the judgment and decree dated 5/10/2023, passed by the District Judge Nalbari in Title Appeal number 2 of 2020, whereby the judgment and decree passed in the suit was reversed.
Then
The facts of the case was, my lord, the original suit was a suit for partition. We claim partition of our ancestral land. Defendant number 1, basically against whom the whole allegations were, he contested the suit by filing a counterclaim also. In the counterclaim, the defendant number 1 alleged that he is the absolute owner thereof of the suit land by virtue of adverse possession
Oh.
against co-owner.
Then
So the suit was decreed, counterclaim was dismissed. Against that order, against that judgment and decree, one appeal was preferred, my lord. Only one appeal. By a perusal of the appeal, that is at page, my lord, at page number 93. The prayer portion of the appeal.
Both are dismissed. Counterclaim
Ultimately-
is dismissed.
I am coming to that part, my lord.
Ah.
If you peruse the prayer portion of the appeal, which they preferred,
Oh, Mr. Counsel.
Yes.
Kindly don't come to the prayer. I don't take judicial cognizance of that because this is not in the type of form. There is no prayer in an appeal.
I understand, my lord.
So whatever they have done, let us be ignorant of such things. Ignorance is bliss sometimes. Kindly come.
What I intended to say, my lord, was
Yes.
maybe the appeal was preferred against the dismissal of the counterclaim.
Oh.
And the counterclaim remained dismissed.
So let us take it as the appeal is dismissed against the year. Now, what happened? Why the appeal was dismissed?
The appeal was dismissed, my lord.
Who filed an appeal?
The defendant number 1. My
Okay.
suit was decreed.
Why it was dismissed? The appeal was allowed. Appeal is also allowed.
Allow.
Appeal was the suit of the plaintiff as well as the counterclaim of the defendant number 1 is dismissed.
Dismissed.
Since your counterclaim is dismissed,
No, that is not my counterclaim, my lord. I was the plaintiff.
understood. But the suit of the plaintiff is also dismissed.
Yes.
Why it is dismissed?
What happened, my lord? In this case, my lord, it is not a case where we sought partition. We categorically mentioned that there were other ancestral properties.
So on the basis of not making those people a party, the appeal was allowed partly.
Part. And another ground was, my lord, that we did not include the whole ancestral property
That is it. For both reasons.
for those 2 reasons, my lord.
What are the substantial questions of law?
My lord, this was not a case where the plaintiff suppressed the fact that there were other ancestral properties. We categorically pleaded that there were other ancestral properties. Regarding those properties, we have got no dispute. Our names are also mutated in respect of the other ancestral property. So far as the suit property is concerned, only with regard to that property, the defendant number 1 has got mutation. And he is denying the title of the other co-sharers.
And
on that count, the first appellate court took the view that because the whole ancestral properties are not included and dismissed the appeal.
now tell me, let us see the written statement filed by that person concerned.
Defendant number 1, by that is at page that is at page 96, my lord.
Can you come to page 54?
Yes, my lord.
is an appeal preferred against the judgment and decree dated 5th of October 2023, entitled Appeal number 02/2020 by the Court of the District Judge, Nolbury. Thereby, the appeal was partly allowed, thereby dismissing the suit and also the counterclaim. The appeal is admitted by formulating the following substantial question of law: whether the learned First Appellate Court was justified in dismissing the suit filed by the plaintiff on the ground of non-inclusion, on the ground of not including all the legal or not impeding the legal representatives for not impeding the wife of late Dinesh Bhattacharya,
Bhattacharya.
Ahary, and the daughter of late Dayamanti Devi, and also for non-inclusion of all properties belonging to
Narayan Sharma. Original Patadar was Narayan.
one Narayan Sharma, since deceased. Issue notice making it returnable by 6 weeks. Steps be taken by way of registered as well as usual. In addition to that,
Much obliged.
what is this IA business?
There was a for stay, my lord.
Stay of what?
Stay of the impugn order, your lord.
Why?
Actually, they might dispose of the
Take on
property.
an application for stay of the impugned judgment and decree dated so and so. Taking into account that the suit had been dismissed, as well as the counterclaim is dismissed, the question of granting a stay to the said order, said judgment and decree does not arise, for which, and as such, the instant application is misconceived, for which the same stands dismissed. Every time you are asking for time, let it go after vacation.
Lordship, kindly timing, Lordship, he'll come.
3 occasions. 10-4, 24-5, 12-6. Every time we are asking for time. What to do? Let's have it after vacations. At the request of the learned counsel appearing on behalf of the appellants, matters stand adjourned to be listed again on 15th of July, 2024.
Six.
Degree of reversal.
Hmm.
Money suit was filed. Issue is, my lord, whether the claim would be covered by Article 21 or 22 of the Limitation Act. Admittedly, it was a loan given, my lord. But the learned appellate court, first appellate court, relying on a judgment of the apex court, has held that it is a deposit. I may take your lordships to the pleadings, my lord. At page 7. That is the plaint, my lord, starts at page 6.
Page
Page 7, paragraph 4 of the plaint. I read, madam. That the defendant number 2 knows the plaintiff and his family members very well. Out of his friendly relation, the said defendant approached the plaintiff for loan and persuaded the plaintiff to lend a sum of rupees so and so and so and so and 50,000 so and so. It is pertinent to mention here that the defendants borrowed the said sum of money in the name of the defendant number 1 so and so. Para 4, madam.
and number 2 knows the plaintiff and his family. On his demand. And
Article 21, if your lordship takes up, no? Just got it. For money lent under an agreement that it is payable, it shall be payable on demand. When the loan is
loan
made.
is made.
Loan is
So it will be within 3 years.
3 years. The suit was admittedly filed in 2007. ma'am.
And what did the trial court, first appellate court held?
First appellate court, my lord, lordship comes to page 41, that is the finding.
Page 40.
1. Issue number 2.
But what was your written statement? You don't deny. You
Taking the money, I don't deny.
no. You don't also admit that it was on demand.
It is on demand, madam. That is not difficult because it is a
No, no,
loan,
kindly see what has been recorded.
Lordship sees my written
Defendants
statement.
in their written statement admitted that the plaintiff had paid the amount to the imam voluntarily and there was no assurance that the said sum would be returned on demand to the applicant. If that is so, can you therefore take the plea?
The money lent to me, madam. Of loan.
21 will apply when? When there is a demand.
Money lent and when it is demand.
No, no, money lent
That it will be
and payable on demand.
on him.
Then the loan, when the date of the loan. But if it is a money lent, but not on demand, then it will be the date of the demand.
No, madam. Then it will be for money lent, 19 will come, madam.
No, no, kindly come to 21. For
21 is
money lent under any agreement that it
Hello?
shall be payable on demand,
Demand.
then on the date of the loan.
on the date of the loan. Lordship comes to 19, madam.
For money lent, for money payable
for money lent.
when the loan is made,
Loan is-
it's okay. But 22, where for money deposited
Deposited.
under an agreement, there's no agreement.
There is no. And my lord, deposited, my lord, lordship would appreciate in a bank or he has given a deposit that you please invest it somewhere, my lord. There the 22 might come. Because if your lordship
The
sees the
instant
judgment
appeal.
on which the appellate court relies on, the judgment of top line should not, it's a 2-page judgment, may I just place
But
it.
Mr. N. Dekar, the learned instant appeal. Directed against the judgment in
29/1/2024.
9/1/2000 passed in money 2011, whereby suit of the plaintiff was decreed. Thereby reversing the judgment and decree dated 21/2/2011, passed in money suit number 2007. The appeal is admitted on the following substantial question: whether the learned trial court, first appellate court was justified in applying Article 22 of the Schedule to the Limitation Act 1963 in respect to a loan, in respect to money lent when admittedly the plaintiff states in paragraph 4 of the plaint that it was to be payable on demand. Issue notice returnable by 4 steps be taken, 6 weeks LCR be called, steps be taken by way of registered as well. There be called. Is the matter for completion of the IA communal hall. Application 5 of the Code of Civil of the execution of 9/1/2000 Judge number 1 Kamrup Metro at Guwahati in MA number 02/2000 code by an order passed accompanying appeal being RSA number 94/2000 had already admitted the appeal by formulating a substantial question of count that if Article 19 or Article 21 of the Schedule Act is applicable, Act 1963 applicable, then the suit would be barred by limitation. This court is of the opinion that the interest of justice would be served for staying the judgment and decree dated 9/1/2000 passed by the Court of the Civil Party in MA number 02/2011 till the disposal of the incident. Accordingly, the said judgment and decree dated
29/1/2024.
9/1/2024 passed by the Court of the Learned Judge number 1 instead till the disposal of the appeal. I stands disposed.
Ben,
I take it also. The respondents have filed an suit below for specific performance of contract
Hmm.
entered into by my predecessor. Below. Now the suit went on ex parte method, and the learned trial court has decreed the suit for specific performance in respect of a land which was not the subject matter of the agreement. Different without the suit premises was decreed without. Against that, they have preferred an appeal. And the first appellate court upheld the decree upheld the decree of specific performance and modified the part of balance amount without. The trial court has said that 2 lakhs balance is there, and the appellate court has said 1 lakh something is there. So my first substantial question of law, whether the courts below were justified in decreeing for specific performance, which was not the subject matter of the below agreement. And second, below, at the time of passing the decree by the first appellate court has given time period, a specific time period for payment of money, balance, for execution of the sale deed, but did not impose any liability to pay the balance amount on the plaintiff concerned. So the decree is in violation of Order 20, Rule 12. And third question, they have, in their plain, they have said that I have rescinded the contract by sending a notice to them. And the both the
Where is the plain?
plain is at page 10.
Where is the agreement?
Agreement, I have not annexed, but I have certified copy. I have certified copy. It will be.
What is the sale deed?
That was earlier salary, my lord. That is in respect of earlier occasion, they have obtained it.
No, that is okay, but this seems to be in conformity with the schedule. You are saying on the basis of the holding number.
Yes, my lord, holding number as well as my lord, boundary,
Huh?
boundary, my lord.
But boundary is also same.
My lord, western boundary is different, my lord.
Western boundary is one own shop. So here is also own shop of the plaintiff and the Tezpur municipal holding number. So and so.
Otherwise, in their
Own shop of the plaintiffs. Here own shop of the second party. So one and the same.
in the appeal, they themselves says that difference with the time.
Let them say many things. It's a question of fact. And you are on, what is the decree pass? You are on
Decree.
order 20 rule 12A.
Well,
Is it? The suit for, yeah, na?
especially performance. Degree is the case 59.
Why the amount was lessened?
Because court has come to pending that some amount was adjusted for the security. And operative party is at 60 million, pay 60.
Why there is no mention about payment of, there is already a payment, it is also the alternate deposit of the balance consideration of rupees 1,16,000 and furnishing of requisition in the court by the plaintiff.
It is after failing, man. After failure, in case of a fail below, but within that 120 days, no payment was made. No such order was made below.
Oh no, this means the same only. Here there is one comma, page 15 of the internal page 15. There should have been a comma. Without that comma, with that comma, everything makes the same. It's a typographical error.
Page below.
It's internal page 15 of the judgment. Why are you not paying the 1,84,000?
Below. I am the vendor leader
So you pay the 1,84,000.
to execute the other part of the degree. Other part of the degree.
You'd be happy. You think so?
But these are unable to do that.
Then take that money. Makes it very clear. With this judgment, one should be very happy. It is also ordered that alternatively the
Yes, yes,
defendant is to return.
Both are there.
So you should be happy with this. This should not have been given by the court.
Yes, either of the one.
Court should have given that in the alternative, if within this period he does not make the payment, you are to return. As per this order, you should be more happy. Return this amount. You can't put to execution. Once you return, that's a finish. Order is wrong. In fact, he should come.
But to my understanding, within 120 days, this was not ordered to.
There's a comma. Comma is missing. So for that, it's not a substantial question of law. You put a comma here. Kindly come to page 16. To the officer of the court as per the provisions of Order 21, Rule 34 of the CPC. You get the point? Internal page 16 of the
Yes.
judgment.
Yes.
Failing which the registered sale deed shall be executed in favor of the plaintiff through an officer of the court as per so and so of the CPC. You just put a comma on deposit of so and so. With a comma, everything makes a difference.
At the time of execution.
That is not Order 20 Rule 8. Okay.
Within that 120 days, if a specific order is not passed.
You file this, you will just file a cross objection and get away. You are in more trouble. Think about it. Ask your client. Give it time. Think about it. The moment you put a comma, matter finishes. Can't be a substantial question of law. Your substantial question of law is on the basis of 27, read with this, Order 20, Rule 12. I understand that. But this, on the face of it, is not a substantial question of law. Second is, you can very well pay that 1,84,000 finished. Categorically say, alternatively, it couldn't have been passed. I think it's an oversight on the part of the learned first appellant. He should come, that why that alternative, please. Happy? Think about it. The SAO, the learned counsel, appearing on behalf of the petitioner, that he may be appellant, submits that he may be given some time for the purpose of obtaining appropriate instructions from his client after the summer vacations. Take this. I think that is the best way. Save yourself in spite of, otherwise you are paying such a huge amount of money in employing Mr. S. Sahu to do all these matters. At the end of the day, he may spend the 1,84,000 on you only. Yes, Mr.
In this case, my lord, appeal has been filed, my lord. Title appeal. The senior division Baksa, having this argument. My lord, here substantial question is that plaintiff.
Is this the case which happened after I passed some order? No, not this. Anyway, tell me.
But
It's a suit for?
suit for degree of title, degree of right title interest and recovery of past possession by eviction. My lord. So for right title, my lord, the appellant defendant has nothing to say, my lord, because he admit that he is a tenant. They are tenant under the plaintiff, my lord. But only point is that they are taking that stand that since they are tenant and plaintiff is a landlord enjoying the land on rent basis, so he cannot directly file a suit of recovery of past possession by eviction. That part of the suit, my lord, suit has been challenged, my lord. And there is a provision, my lord, under subsection 4, section 54 of the Tenancy Act, settlement. of
What
tenancy
land
act,
is this?
my lord.
Land is not urban area. Where is the land?
Rural area.
Okay.
The rural area.
So you are a tenant admittedly.
admittedly.
Then
My lord, our point is that, since we are entering the land on rent basis, so the suit so far relating to eviction is not maintainable directly. First, they have to obtain a decree for rent, recovery of rent. If they fail to pay, then only suit for recovery of possession by eviction is.
Fine.
Yes, that is the provision, my lord.
which provision?
My lord, subsection 4 of section 54 of the Assam temporarily settled areas tenancy act 1971.
So he was a tenant under
Yes.
under that act.
My
He
lord,
was a tenant under the Assam temporarily settled area tenant is here.
my lord, that is the pleaded case, my lord.
Let us see why will he make a mistake?
Lordship, may I kindly have a look at paragraph 8 of impugned judgment. Page starts from page 16, 11 paragraph, my lord, 8 at page 20.
No, does the plaintiffs admit that you are his tenant?
My lord,
No.
that is their pleading, my lord.
No,
That
where is it?
we are enjoying the land on rent basis.
Where?
Lordship will find their plain is at page 7. 11 paragraph 4, my lord.
Are you an occupancy tenant?
My lord,
How?
we are occupying the land since
No.
1984. My lord.
No, you sold the land.
No, my lord.
Yes.
Part of the land is sold. My lord.
No, that only he is asking only for a 1 bigha.
Yes, my lord. We are also disputing only 1 bigha, my lord.
But that portion of the land you sold.
But we are occupying the land as we are allowed to occupy the land.
No, he gave you. On one hand, you are saying that you are a tenant.
My lord.
That means you admit that the plaintiff has given you the land on Adi.
My lord.
Then
My
how
lord,
is it possible?
My lord, there, my lord, my
You
lord,
sold the land to the plaintiff on 20/2/1984.
yes.
Then
Then, my lord, my lord, he unable to cultivate the land, and therefore we are allowed to cultivate the land.
no, you were only allowed on 33/2009.
No, my lord. That is the disputed fact, my lord.
What
My lord,
disputed fact?
we are occupying the land after sale in the year 1984. That is, my lord, we have stated in our WS, my lord.
Then? What does the Munsif hold?
Lord, you will kindly have a look at, my lord, our WS, my lord, under paragraph 16, page 14.
So what is wrong? Rightly,
My lord.
rightly passed.
Sir.
The court have
So
duly,
far, my
both
lord,
the courts
right
have
title,
duly.
we have nothing to say, my lord. Only that part, my lord. We are admittedly we are occupying the land, paying some rent. And therefore he cannot file this suit, my lord, for
No,
recovery.
you could not put
directly,
it.
my
You admittedly, you admitted during the cross-examination that the last 3-4 years you have not paid the rent.
Because he is demanding exorbitant rent.
Whatever may be,
My lord,
then what to do? What does the provision say?
provision says that for enhancement of the rent, he should file a
When he does
claim
not,
under section
when he does
29.
not receive, what does the provision say?
May take up the matter any other day, my lord.
After vacation.
Right.
The request of Mr. A.R. Sikka, the matter stands adjourned to be listed after. Fine. Yes.
Well, this second appeal against even the judgment of reversal.
What is the case about?
It is a suit for specific performance of the contract. I were the defendant in the suit,
You are the plaintiff.
defendant.
And the suit was dismissed.
Suit was dismissed.
What ground?
But the suit was dismissed on the ground that the agreement, that was not an agreement for sale, but it is a kacha deed of sale.
What is this Kacha deed of sale?
It is not registered deed.
It is not required to be registered. An agreement for sale required to be registered, no.
But that was actually not the agreement for sale, but that was a sale deed.
Huh?
That was a sale deed. Terms and conditions we sell deed. This is not an agreement for sale. It is in vernacular manner. The writing is that manner.
Where is the agreement for sale? With one.
One minute, the copy, this is minute in vernacular.
But this is supported by the other documents which says that there would be the sale permission.
Sale permission is,
So all these things are there.
yes,
So this document is further supported by those documents.
sale permission, the,
So even if whether there was an, let us assume that there is no, this document is not. But then also there is an agreement, oral agreement also.
oral agreement also it can be specifically.
Then- What is wrong?
Well, when it is a suit for specific performance of the contract, there must be under section C, readiness and willingness. In the page 8, paragraph 14 of the plain, the cause of action for the suit arose on such and such the date of execution of the agreement for sale on 30/8/2017. There is no explanation between 2001 to 2017. Therefore, the plaintiff has failed to prove his readiness and willingness to execute it.
Paragraph 10, he pleads. Of the plaintiff, he pleads that the plaintiff is still ready and willing to purchase the suit land, but defendant is wrongfully avoiding
But
of the plaintiff.
so far cause of action is concerned, there is no mention from 2001 to 2017.
No, but this action, forget about that agreement for sale, whatever it may be. On 30/8/2000, the date of filing application before the Visa for land sale permission, was it a joint application?
That was a joint application with my
2017. So then also that also shows that there was an agreement for sale.
oh dear, there was some
Then there
mistake.
is a sale permission given on 22/12, the date of obtaining so and so. I accepted, and the date of refusal to accept the agreement for sale and the cause of action still subsists in so and so. So then, no case.
There was no readiness and willingness.
Readiness and willingness is already there. Paragraph 10 days, he categorically pleads, and the proof is also must have been given, the evidence is given. Let us see what do you
2001 to
say in the written
2017.
statement. Huh?
2001 to 2017, there was no any date for readiness.
Understood. But as on 2017, you got the made an application. On that very day, you both of you must have filed an application that I am willing to sell and he is willing to hear.
The original landowner was died in the meantime, my lord.
Whatever may be, the suit is against somebody else.
Yes.
The whoever it is, the legal representative. When you file an application, forget about exhibit 1. There was an application out there by both parties saying that we are willing to sell, and as such seeking the permission. And on the basis of that, the permission was granted.
My lord, there was also another another thing, my lord. Their case, the plaintiff's case is this. At the time the BTC was there, the land sale permission was required. But immediately after the execution of the agreement, the deed, the BTC was not created. They could have obtained, execute and register the sale.
Understood, but that is apart from the point. On this date, you have filed a joint application by which you want a sale permission. Wouldn't that constitute an agreement for sale?
That is of course right.
Then,
I may give some time to
Better. At the request of Mr. A.C. Sharma, the learned senior counsel, matter stands adjourned to be listed after the summer recess.
Next item also same.
Summer recess.
Next item.
Next date,
The next item.
same. Take it. Seven. Mr. Sharma, I ask you to bring on record the affidavits, bring on record the exhibit, the application for sale, as well as the sale permission. Next date, Mr. Plaintiff, the appellant shall bring on record the application for sale which was filed, as well as the sale permission so granted, which have been duly exhibited before the trial court.
My pleasure.
Yeah.
Reversal, judgment and decree. My proposed substantial question of law basically on perversity.
On
Perversity. You
The
will find
perversity.
my plan at page 7.
huh?
Page 7, annexure 1. Very short plan, Lordship. Kindly peruse from paragraph 3 to 8. Plaintiff was Caro, who preferred this suit against insurance company, seeking declaration of insurance policy of 2013-14. Her person as applicant.
When did the accident happen?
It was taken place during existence of stolen
policy.
Lordship 2013.
So it was during this period.
Lordship.
Then what is your case?
My case was they denied to accept that policy on the ground that my check was dishonored.
Take off
Dishonored
the check for premium
premium.
was dishonored.
That
When?
was not communicated to me. That was not communicated to me. That was true, Lordship.
Check was dishonored. As such, they have repudiated the policy.
Yes.
And for which you filed a suit. Now, when did you give the check? 22/2/2013 means prior to that,
Prior to that, Lordship.
and the accident happened on
2011-2013, stolen.
was it from your account?
Yes.
So well, you must be knowing your account have been debited or not.
That was.
Well,
If your
rightly
Lordship
done.
kindly peruse judgment of learned trial court, Lordship will find.
Trial court, forget about trial court. The question is, if it was a third party, I would have considered. But it is the first party. Then, okay.
In this regard, Supreme Court 2012-5 SCC 234 is very much clear.
What does it say?
It says, Lordship, that must be communicated.
Which one? What, is it a case of third party?
First party, Lordship. Before coming to that, if you kindly peruse some findings of learned trial court as well as first appellate court.
Yes, again third party. I told you, the law is settled. If it's a third party, then obviously they will pay and recover. That is another aspect. But here is a case where your check was there. that insurance policy have been issued, your check bounced, and you knew it. I would have understood 1-2 days, year after, thereafter. But the check was bounced much earlier. You must have given the check prior to 23/2/2013 before the check. Then,
But Lordship, that
Okay.
particular appellant Lordship, not regularly used set.
Huh?
In,
you for the purpose of 9 months did not know that your account was debited. Then pay these 4 lakhs. You should be more careful.
if your
What do you say, Mr. Vatsaji?
if your Lordship can,
The thing is that the premium has not been paid. So the policy has not come into play.
Absolutely.
So all these
And
things are not.
third party would have been a different aspect.
No,
Third-
what I
third-
know about insurance, until the premiums are paid, how can the actual policy come into play? My lord? Because you have not paid, that is all. So always so many explanations will not be necessary. So here the case is the payment has not been made. So the policy will not come into play.
the insurance company has also failed to communicate. That is.
So
true.
what? You knew it from your own account.
Nowadays there's an SMS also, my lord, in the
Ah.
mobile. Immediately after it, yeah. And when a check fails, they charge you also.
Don't give him any more idea about SMS. Now take your seat.
Can we consider some days if
After vacation. Tar Ali, the learned counsel appearing on behalf of the appellant, seeks some time to take further instructions from his client, list the matter after the summer recess.
Matter does not relate to stay matter. Because there was a direction for it, taking steps by postal circuit. And my lord, 9/1, 9/2, and 12. Accordingly, my lord, we have taken steps and this affidavit is being filed. 12, my lord, straightway refused to accept. Rest of the, my lord, respondents are already served.
Mr. Purkasto, what are you challenging?
And I have challenged, my lord, he pair for appointment of Amin Commission.
Huh?
Amin Commission, my lord.
So,
Under order 26, rule 9.
is wrong?
Payment of matters come for affidavit.
No, for not to extend. Not to extend the stay.
No, there is no stay. No stay,
No stay?
no stay.
Huh?
It's a
Interim
wrongly-
order passed earlier shall continue.
My lord, there's stay.
Then I won't extend the stay then.
That's it. I am not sure. I've forgotten my. Hasn't he stay?
We vacate the stay. As you are not aware that there is a stay.
Because my lord, I was a little bit confused
Ah,
regarding those steps.
then
That
now
if
the
there is-
argue, what is the wrong?
If there is a stay, let the stay be continued.
Absolutely no. These matters are for the first thing immediately to be finished off.
No, immediately after vacation, they did not even
No.
appear.
That is for the first time RSS. They should not get a shock immediately. This is for a 2016 suit, 2019.
19.
And do you know what is this interim order passed?
What?
That till the next date,
Yes.
the judgment shall not be pronounced.
My lord,
And
even then, my lord,
from 2019,
without,
5
my lord,
years you have done the
without raising any controversy.
Then calmly come to what is it? What is the wrong thing about the
My
order?
lord, today though I am not prepared, madam, because I have the impression that total first necessary order regarding affidavit.
Chalo. List the matter tomorrow.
Tomorrow, my lord, after vacation,
Absolutely, I'm okay.
after vacation.
The hawk. Mr. A.K. Purkasthar, the learned counsel for the petitioner, seeks for an accommodation. List the matter after vacation on 22nd of July 2024.
My lord, I'm sorry, my lord, extremely sorry. 24th.
Okay, 24th of July, 2024.
My lord.
Full stop. It is also noticed that on 14/5/2020, the interim order was directed to continue till the next date fixed. However, on 28/4/2023, the said interim order was not extended.
And so far as my lord affidavit is concerned, Lordship kindly make an
Not
observation.
necessary.
My lord, notice is over.
Okay. I am not extending any interim order because there is no interim order which is what I mentioned.
It is up to your lordship, my lord.
No, it is there. You see, last time when it came up before Justice Nandi, she did not extend the interim order.
My lord, she did not extend.
And that is why you were also right in coming to a opinion that there was no interim order.
On that day, my lord, I was not ever even, my lord, there was stay order and there was a lapse on my part to renew the prayer or to make a further.
So there is no interim order, what to do? Anyways, I may only recorded it, made it clear.
All right, my lord, then lordship may fix the matter on a particular date for disposal.
I fixed it on
All right,
24th.
all right.
50.
And my lord, so far as the affidavit is concerned, notice.
Not necessary. If
Alright.
I am sitting, these things are not necessarily relevant. Yes. What is this?
My lord, this, my lord, actually on the point of
Huh?
eviction. My lord.
By application, here, read
my
with
lord,
friends as paid to stay the
I
further
filed a
proceedings
petition before the-
pending before the court of Iman. Why?
My lord.
Why you want to stay?
No, my lord,
What are you challenging here?
I'm challenging, my lord, actually, he filed a suit, my lord, for, actually, the, one flat, my lord, the sale by the purchase, promoter to both, my lord. First, it was to me, my lord, then against me, the half price to him.
Huh?
I purchased in 2012
At
the cost of 23 lakhs and other, actually, it is the amount of 2,50,000, 25 lakhs. And my lord, I got the possession certificate. I got the registration also. In 2012, we got the possession certificate. I was in possession, and it was registered in 2017.
In your favor?
My favor.
Ah.
But in the meantime, my lord, after my lord, completion of my getting my possession certificate, my lord, the same builder, my lord, sell it to my lord plenty gold.
After your possession?
After my lord giving my possession, after 1 month of giving my possession, my lord.
Sell it?
Sell it, my lord, in 2016, my lord. But
Before?
then sell it.
And yours is 17?
My sale 17, but my agreement for sale is 2011.
And his?
His, my lord, probably 16, my lord.
Then?
And he's very interestingly, it is in half price, my lord. He is getting 10 lakhs in Ulubari, a flat in 10 lakhs. My lord. Anyway, I'm not.
But you have not challenged it.
My lord.
You
No,
have not
I am
challenged.
I'm in possession. He filed a suit.
But your sale deed is subsequent.
Yes, my
Then-
main sale is subsequent.
Then 48 will come in.
Exactly.
Isn't it?
Yes, that will
Then-
come.
Ah.
But I am not on that. What happened? He filed a suit, my lord. Then when suit was filed, I made an application. By this time, the Act has come into force. So my pair was there. So since it is a dispute between the promoter and the LOT, my lord, so it can be maybe sent to the.
Now, can the RERA set aside a sale deed?
No, my lord cannot. Correct. Correct, my lord. But so far is my lord, title is he cannot claim title from me, my lord. He can title from the promoter, my lord. Because I also genuinely purchased this.
No,
my
no,
lord.
no. When he claims a title from the promoter, it includes also the title from you, because you are now interfering his right. Your sale deed is also putting a cloud on his, isn't it? That is.
This is my suit, lordship. So
That is his
contention
suit,
of my plant
No,
will
my lord,
say the
I
jurisdiction.
did not came to the court because my lord, because I was not in, because it is also registered in my favor also. I am in position, my lord. So now he
So-
came, my lord.
Why not? The letters sale deed be there. All these things. Well, show me the suit.
Yes, Lordship will find kindly peruse first fair person, Lordship will find at page 23.
Mr. Ali, kindly come directly to the point. Where is your suit?
Page 12, annexure 1.
Page,
12, annexure 1.
where is the prayer?
Fair at page 23.
93.
He also paid for recovery of possession.
So, rightly so.
Page 23, madam. There is page 23.
Page
Page 23.
23.
23.
Tulude is the person who made the problem.
Yes, Lordship.
Who sold this?
Lordship, agreement for sale.
Who is
was reached-
Tulude? You are Tulude.
Yes,
And Gargi Associates,
is the builder.
Pranjal Bharali.
They are managing directors.
Okay. Good for declaration, realization, cancellation of the deed, realization of 10 lakhs. Are you asking money?
Lordship, damage and compensation.
Okay. Interesting.
Page 23, my prayer. Declaration of right title interest in view of my salary that was registered in the year 16. Recovery of possession.
Possession of. It's so and so. When was the suit filed? 2018. In the meantime, the RERA Act has come.
Lordship, what happened?
Where is the RERA Act?
Issues were framed in the year 2019.
Ah,
Kindly peruse issue.
what? What is there?
They had also filed draft issues, Lordship. On the basis of draft issue filed by both the parties, these were issues were framed.
Hmm.
Issue number 3 and issue number 4.
Hmm.
That itself shows that except civil court, no other court can take up this case.
Take on you. Five-line order?
Really, my lord, this type of dispute always goes to that, my lord, because he may
No.
be allotted some other, my lord. I am also
Because
saying-
can he cancel?
No, my lord. Promoter
cancel?
No.
Let's see the power of RERA. Power of RERA to cancel. What they can do?
No,
And where is the bar?
No, Lordship.
Bar is 79.
70?
Nine.
No sale shall have duty to entertain any suit or proceedings in respect of any matter in which the authority or adjudicating officer or the appellate tribunal is empowered under the act to determine, and no injunction shall be granted by any court. Where is the power?
My lord.
Yes, give this thing to Mr. Mohanto.
That must be between builder and flat owner.
Okay, let
That
us
plus
see.
it.
Well, let us see where is the power.
As part of title, there is page 17, my lord. Section 17, my lord.
This has nothing to do.
Only there is section 31, 11, 12, 14, those are effective.
Filing of complaint with the authority. Any aggrieved person may file a complaint over as the case may be. Rules and regulate. So he can't file against you.
My lord.
Can he file it against you?
But he, my lord, claimed title from me, my lord.
And he's not claiming title from you. He's claiming title from. He's claiming that he has title. He's not claiming title from you or even from Gargi. He says that he has the title on the basis of the deal.
Sorry.
That's true, my lord. What I am doing, your lordship kindly see the preamble of this act, my lord. Why I am submitting this type of dispute, my lord. Promoter can immediately, because that is, if it is his genuinely purchased from the promoter, then definitely he will be allowed, because my case is also genuine mine. Because your lordship kindly see my hard-earned money in 2012, I have paid everything by bank account.
So you go to RERA. You are so happy. Go to RERA.
No, my lord, I am not doing this time now. He is doing.
No,
this. I
your
am going-
title. He is also a sale deed. He has
Yes.
also a sale deed of 2016. In view of 48, he has a better right.
Correct.
So under such
no, so far is my lord,
circumstances,
so far is my
now
lord.
so shouldn't you be advising your client to go to RERA? Go to RERA. If you want so much.
Definitely, my lord, I'm in possession, that's why,
Then
my lord, he's claiming possession.
What
from
do you
me.
want? Withdraw, dismiss, which one?
No, only, my pair was mean before the court below was that, but send it to error. That was my pair, my lord. That was rejected
You
again,
made
sir.
a very simple, innocuous prayer, which was duly, rightly rejected by the trial court.
Your lord.
And now you have made that innocuous prayer a hardened prayer and come before this court. And you got to stay. Therefore, we see the first order. What does it say? Testing order, first order. With due respect. By this application under Article 227 of the Red with 115 and Section A, or you could have also added under the Article 226 everything. The petitioner has prayed for stay of further proceedings.
That is their exact aim, lordship. That is their exact aim.
That's
That's
it.
not the aim, my lord.
Suit is
Suit
a-
is how it is. Yes,
His,
suit is
his
how
was
it
an
is.
innocuous prayer. Now he wants to give impetus to that.
No, actually, my lord, your lordship tell it then. Why this genuine processor will go now, man? Your lordship.
Go to RERA. You are happy enough. Why you are not
No,
going?
I am in position, my lord. I mean, that is
You
not.
are in possession, but your title is defective.
My lord, at that time, no, my title is not defective. My
Your
lord. I don't-
title, no, your title, in fact, if I was in your shoes out there, I would have very well not only asked for a suit or go to RERA, ask them that this is the illegalities which have been committed, ask them to take note of that. But what you are not doing is you are trying to delay only on the basis of an agreement. Yes, you have a due right in view of Section 19(1)(b) of the Specific Relief Act. You have a better right. But the fact is, unless you do anything, you can't be. You are trying to be act as a defense. Don't you think that your case should have been more offensive instead of being offensive out here in the High Court? Maybe Mr. Mohanto does not like to go to the trial courts.
That, my lord.
Yes.
Actually, my lord, probably that builder has committed wrong. Maybe, my lord, he can allot another flat in that building, my lord. Because
Then he will go to RERA for that.
he can also, my lord, go to Reham.
Why? You are not going. You should go to RERA. Your
My allotment was done, my lord. I mean,
Mr. Mohanto, why are you not understanding?
no, I
He
understand, my lord.
has a title on the basis of a document. You don't have a title on the basis of a document. You only have an agreement for sale. And an agreement for sale in terms with Section 54 is only to that effect that you have a right to get any other document. And RERA may help you more, not him.
That's why, my
Ask
lord,
for
that's
setting
why, that
aside.
is why, my lord, I make, my lord, pair the entire matter will go to, my lord, yes, that is coming to force in 2021. That RERA Act, my lord. That's why, my lord, to just sort out the problem, my lord. Otherwise, my lord, we'll all be in trouble, my lord.
So what to do? How many years did you got to stay?
No, it's one thing, this year. Suit is of 2018, that is, this is filed in 2022.
20?
22. That's it?
2 years.
Yes.
The loss he has occasioned. Personally, Mr. R. Ali,
No, that's,
for his
my lord,
appearance,
that's too. Actually,
we take it every day, 12 dates in a month. 2 years, 24. 5,000, 24. That's me.
no, that's my lord, your lord, you can leave.
Cost.
I'll leave it to your lord.
Eh?
My lord, no, my prayer was, my lord, on the.
Your
my
prayer
lord,
was
your-
very innocuous there, but now you have strengthened it here. What to do? Dismiss with cost? Which one? I think better
I'm
you
given
withdraw.
a liberty to go to a Reham. Your lord,
You are always at Reba. Why should I ask you? You should always. I say that you want to, we are also avail other opportunities.
my lord, they will take advantage of that. my lord.
Yes. You better withdraw. I'll dictate the order. Heard Mr. T.J. Mohanto, the learned senior counsel, assisted by Mr. P.P. Dutta. Who is this? So and so. Appearing on behalf of the petitioner and Mr. R. Ali appearing on behalf of the respondent. The learned senior counsel appearing on behalf of the appellant, petitioner, submits on instructions that he would not like to further press the instant writ petition. The learned counsel submitted that in view of the Real Estate Bracket Regulation and Development Act 2016, which came into force in the year 2021.
No, that is in 70.
When did it come?
70, Act of
The year 2017. And as such disputes would have been would have been better resolved before the authority under the said act, that an application was filed for referring the said dispute, the dispute entitled suit number 381/2018 to the RERA authority. The learned counsel further, senior counsel further submitted that the learned trial court, however, rejected the said application, and it is under such circumstances the instant application has been filed. It has also been submitted by the learned senior counsel that the RERA Act is in relation to has fairly submitted that in terms with the RERA Act, the some of the prayers made in the suit cannot be adjudicated. Be that as it may, the petitioner also is aggrieved by the actions of the respondent, the builder. He therefore submits that he would not further like to press the instant petition, but withdrawal of the instant petition should not preclude the petitioner to avail such remedies otherwise available under law. So, taking into account the above, this court therefore closes the instant petition with withdrawal. It is, however, made clear that the withdrawal of the instant petition shall not preclude the petitioner herein to avail other remedies which are available under law, more particularly under the Real Estate Bracket Regulation and Development Bracket Clause Act 2016. The interim order so passed on 21/12/2022, 21/11, na? 21/11/2022. Where is it? 21/11/2022 stands vacated, and the parties who are duly represented are directed to appear before the learned trial court on when? The billing starts when? He doesn't go.
First week of July. So
On-
direction may be given. Also,
On
what
5th
happens,
of July
they were aviator.
2020.
They appeared as caveator in the year 2018 itself.
Enough.
Since then,
5th of July, go there. He is not going to appear. For him, it's a summer
the
holiday.
injunction petition is yet to dispose of lordship since 2018.
I am not here to take up
Yes,
all
sir.
this.
Deeply.
WPC 6909 of 2015.
It's the opinion of this court that the interdepartmental communication dated 25/2/2013 as well as the operational guidelines dated 7/5/2013 cannot limit the petitioner's entitlement in terms with subclause 1 and 2 of clause 6 of the notification dated 27/7/2007. Be that as it may, as this court does not have the expertise to decide as to whether the various components which the petitioner alleges the same ought to be included in the entitlement, as they were a part of the industrial plant and machinery as erected at the site. This court directs the respondent authorities, more particularly the respondent number 3, 4, and 5, to make assessment of the petitioner's entitlement purely on the basis of clause 6 of the notification dated 27/7/2007, without being influenced by the communication dated 25/2/2013, as well as the operational guidelines dated 7/5/2013. The said assessment be carried out by the respondent number 3 to 5 within a period of 3 months from the date a certified copy of the incident judgment is submitted to the respondent number 5, and thereupon the respondent number 3 to 5 shall do the needful for the purpose of providing the additional benefits to the petitioner if so entitled after making such assessment as directed herein above. The respondent number 2 is also further directed to take appropriate steps upon assessment being made by the respondent number 3 to 5 so that the petitioner is conferred the benefits if so entitled after the assessment made. The entire exercise be completed within 5 months from the date the certified copy of the instant judgment is served upon the respondent number 5. Okay.
Lordship, regarding item number 41.
Hmm?
Item number 41, Lordship, I have an urgency. Upgraded, Lordship.
Item number 41, you have an urgency.
That is not taken up today, Lordship, the petition.
Okay, we'll take it up. Inform the other side.
The mobile number is not available in the.
You are there.
My learned senior counsel, Mr. P. Dekar is here. On behalf of P. Dekar, I am here, my lord.
You are there.
Yes, respondent, for the respondent, lord.
Fantastic. We'll take it up after the stay matters are over. Ask your senior counsel to come.
In this case, I have taken filed an affidavit regarding justice service. The petitioner is unable to serve the notice. I specifically mentioned in paragraph 6 of page 33.
The person works where? Where does the respondent work?
The Honda company,
Huh?
at Aichol. Honda company. I mentioned the office name.
Hulda.
Yes, Lord.
Now you say out here that you went to this office.
The office both.
Petitioner went to the office of the respondent at Honda Bigwig Aizol, West so and so near Land Revenue Branch.
Yes, Lord. That is the office. There are two offices, Lordship. Visited two offices as well as his residence also. And this
Now there is only one office where you went.
the petitioner went to the
Went to the office of the respondent situated at so and so.
Honda so and so Aichol near Land Revenue and Settlement Department
And go to Honda.
and go to Honda. Two offices.
Okay, we do one thing, madam.
Okay. And she went to the court, Lanet court below, Lordship. On that the case was fixed first May. And handed over the certified copy of the orders as by this honorable court to his counsel.
Okay.
Here,
Look, pursuant to the order passed by this court on 10/4/2024, the petitioner has filed an affidavit of service wherein the petitioner had stated that attempt was made to serve the respondent at his house at his residence at Lower Jorkhat, RKAWT near Jote Bakery, Aizol, as well as also in his office at Honda Big Wing, Aizol, as well as Go to Honda, GOTU, Honda. However, the service could not be meted upon the respondent. The petitioner also tried to serve a copy of the orders so passed by this court to the counsel representing the respondent before the learned trial court, which also remained unsuccessful. Taking into account the above, this court where is that court?
district, additional district judge Aichol, Lordship.
Okay. This court directs the registry of this court to send a communication to the court of the additional district judge Aizol, Judicial District Aizol, along with a copy of the instant petition so that the said court can effect service upon the respondent by way of usual process. and more so, taking into account that the respondent had approached the state court by filing the divorce proceedings. Pusto. The learned counsel for the petitioner is directed to file an additional copy of the writ petition of the transfer petition before the registry, so the registry can take appropriate steps. List the matter again on 2nd of September 2024. The interim order passed earlier shall continue till then. 2. Yes.
Wait, please, for your lordship. Lordship, in the present matter, we filed our Vakalataman entered appearance. Meanwhile, lordship, it's paid before your lordship that 1 week time may be granted to file our response with regard to the transfer petition filed by the.
What is that? He stays at where?
Lordship?
Dibrugarh.
Yes, lordship.
Five stage at Dibrugarh.
Stay in Dibrugarh.
Husband is at
Guwahati.
He stays in Dibrugarh.
Wife stays in Guwahati, Dibrugarh, and husband stays in Guwahati, lordship.
So, why she shouldn't be sent to Dibrugarh?
Lordship may give only 1 week time, lordship, to file.
No,
our
she has to
response.
come and appear before the court.
Lordship, meanwhile, the matter has already been stayed in the.
Understood.
Lordship.
But then also she has to come and appear. But in Dibrugarh, you can appear through your advocate.
Yes, lordship, but
So-
meanwhile, lordship, we needed prayer, lordship, 1 week time must be given to file our response, lordship.
Why? When did you receive the notice?
Lordship will enter appearance on 6th of.
You want a divorce?
Lordship.
No, isn't it your urgency?
Like I need to take
Okay,
certain
we can
instructions from my client, lordship.
we can adjourn it for the next year, July. July, what will be next year, July 15, 2025? How does it matter? How will she come out here every time?
Lordship, it's a discussion of the court whether the lordship may transfer or not. Lordship may just give 1 week time to submit my response, lordship, reply, lordship.
Only answer is, question is whether she stays in Dibrugarh.
Lordship.
So, matter over. I don't need anything more. Does she work? Does she work?
Lordship, I have to take instructions from my
Oh,
client.
you don't have instructions and you are appearing. Take your instruction over the phone. We'll take it up at 3. Does she work? Does she have a source of income?
Lordship,
There's nothing else.
yes, lordship, but lordship may just give me 1 week time, lordship, to
You-
find my
you-
response.
You say whatever may be. Matter is disposed then. Unnecessary. Transfer petition shouldn't be there for long. You want this transfer petition? When I came initially and joined, I was a judge. The transfer petitions of 2016 were pending. Now we find 2024 transfer petition. That gives such happiness and solace. Then,
Lordship may take up the matter any other day, lordship.
you want to file?
We file our response, lordship.
Why? Except material instruction, there is no other reason.
Lordship may
Yeah.
take up the matter tomorrow, lordship.
Does it have any other reason? Take your material instructions.
Lordship may take up the matter tomorrow, otherwise, lordship.
Why?
Not today, lordship.
Then we'll impose cost. The court's judicial time.
I will seek instructions from my client, lordship.
3 o'clock. Fantastic. Yes, what has happened?
Steps has been taken, lordship, and justice service was also started, lordship, on 17/6, lordship.
You have served justice service.
Filed, lordship. Tomorrow we'll file the affidavit of service, lordship.
You have not filed the affidavit of service. When you are filing,
Tomorrow.
counsel appearing on behalf of the petitioner submits that tomorrow he would be serving. you will be filing the affidavit of service. Taking into account the above, list the matter again in the month of July, on 19th of July 2024. Interim order passed earlier shall continue till then.
Please, Lordship.
Yes, what is this?
We have taken steps upon the response by the registered post that was returned answered. And accordingly, we have taken dusty service and thus we have not yet as of the dusty service. Paying before your Lordship, kindly give us 7 days time, file the affidavit, Lordship.
Huh? We have not taken steps, but
We have
why
taken
haven't you
steps.
filed the affidavit?
We have taken steps, my lord, through the dusty service, but we have not yet received the status of the dusty service.
Then we have to take fresh steps by way of dusty. The counsel appearing on behalf of the petitioner submits that the affidavit of dusty service could not be filed. Steps have not yet been received back. List the matter again on 29th of July 2024. The petitioner is directed to take fresh steps by dusty upon the respondents and file an affidavit of service on or before 24th of July 2024. In addition to that, the petitioner is also directed to take fresh steps by way of registered as well as usual upon the respondents, taking into account that the office note dated 15/6/2024, wherein it has been mentioned that the service could not be meted up upon the respondent number 1 in view of the location being could not be traced out. Just list accordingly. Interim orders passed earlier shall continue till the next date. Yes, what is the urgency?
One document is for Lordship. That document is to be exhibited, Lordship. Day after tomorrow is the last date given for filing fee.
What order did you challenge?
Is number 48, Lordship.
Yes, then
Document is required to be exhibited, Lordship, with DW.
what order is this? You are challenging 15/2/2024.
Yes, Lordship.
Who has the tenancy agreement?
Tenancy agreement is with them, Lordship, and
Have
we
it?
have one photocopy, Lordship. Actually, my senior is coming. From my limited understanding from my senior, there is an existing agreement in the year of 2016.
2009.
2016.
2016 you're drawing it, but there is no denial to the aspect that there is a deed of agreement as per the impugned order.
My lord, my lord, my senior is coming. Lordship. My senior is coming. He is well acquainted with the facts of the case.
Who is your senior?
Mr. P. Deka is coming. He has
Mr. P.
P. Deka, Injunctive. He's coming. Lordship, he has just informed me. He's
Okay. Let us keep on waiting for him.
sorry, Lordship, for the
Then
Yes,
I told you at 2. You mentioned it at 2.
yes.
Then
I informed him, Lordship.
what should we do? Okay, we'll take it up at 3 along with the other matter. And this time if your senior doesn't appear,
Yeah, Lordship.
then nothing happens.
Lordship.
220 for the
After taken the steps, usual and for the
Yes. What steps should you take?
usual and postal ID. Then process and
Huh?
postal ID and usual process.
What postal lady? This postal lady has not happened out here from 2014 and you are going to have it now. This can't happen like this. Underground, that the service have not been meted for the last 10 years, we should dismiss the appeal. What do you say? Fantastic idea. Without them, the court cannot proceed. I gave you a last opportunity what to do, making it very clear. Under such circumstances, the appellant herein has to take recourse to an appropriate provision of law. If these appeals are to be further proceeded with, taking into account that without due process service upon the respondents in accordance with law, the instant appeals cannot be proceeded with. Then you need to go for paper publication.
Yes, paper publication.
Have you filed an IE? Have you filed an IE for that?
Yes, Lordship. After that, I have
When?
after one.
You have not
Yes.
filed. I gave you an opportunity. You have not done so. Yes,
Which
Mr.
paper?
Bachcharji, what do you have to say?
I am appealing for the collector.
Yes, what do you have to say? The service have not been meted out.
Get the last
What to
chance
do?
of paper.
Can we have that 50% of the money?
That was given in 2014.
Yes, that is
Then-
2004. Yes.
Four.
For that, after that 10 years had passed,
Not 10 years, 20 years.
yes, 20 years, yes.
Then
And our papers also, my lord can have a look. They have faded and all the typing has disappeared.
yeah,
For 20 years. 20
20
it's been
years,
lying
it cannot remain like this.
Chance for filing an I and for paper. Get the last chance.
I think this
Get the
needs
last
to
one.
stop.
Get the last chance. Lordship. Just I
Lahore. This court, by an order dated 27/5/2024, made it very clear that the appellant is required to take appropriate steps as per the provisions of law so that the service can be meted out upon the private respondents. Pursuant to that, the appellant have taken steps through usual by issuing usual notice as well as by registered post upon the respondent numbers 1 to 4. Full stop. It is relevant to take note of that for the last 10 years, the appeals have been pending on account of non-service of notice. Full stop. Under such circumstances, this court fixes the matter again on 19th of July 2024. 19 no, as you earlier, no. Fixes the matter on 29th of July 2024. In the meantime, if the appellants do not take appropriate steps so that service is meted out upon the private respondents, this court has to close these appeals in order to bring a closure to the proceedings.
drastic sir.
What does the service? You don't know where they are and you want to take them. Go do dusty service.
Proper address and
Huh?
color.
No, cannot. Okay. This court, however, grants permission to the appellants to take effect justice service upon the private respondent number 1 to 4 and file an affidavit of service on or before the next date. Who died when?
Respondent number 1 died, Lordship.
When?
Lordship, he died.
How many respondents?
There are some other respondents also, Lordship, but the respondent number 1 is the plaintiff, Lordship. He died on 27/9/2023, and we have informed them on 10/11/2023. Same way, Lordship, in the year 2019, I have informed them that appellant number
Sudut
1.
Kumar Roy died.
Yes, Lordship.
He got the decree.
Yes, Lordship.
Others become useless.
Lordship, they are vendors.
Okay.
Lordship.
It
Yes,
has been
Lordship.
brought to the notice of this court that the respondent number 1, who was the plaintiff, had expired on
27/9/2023.
27/9/2021. 21.
23.
It has been mentioned as 27.
No, Lordship.
No, it has been appellant number 1 expired.
Appellant number 1 expired. We informed thereafter, Lordship, after a long gap of 1.5 years, they filed Lordship substitution along with abatement and condonation. We have not objected, Lordship, is because we have urgency. That was allowed. Now, respondent number 1 died. We informed them.
Had
provided all the
expired on
27/9/2023.
27/9/2023. Pusto. This aspect of the matter was duly informed on 22/11/2023, as is reflected in the order sheet. However, no steps have been taken for filing appropriate applications for substitution of the legal heirs or for setting aside the abatement. Under such circumstances, the instant appeal abates inasmuch as the respondent number 1 was the plaintiff. Consequently, the appeal stands closed.
Obliged, Lordship.
What time? Closed.
Obliged.
You do whatever you like. The LCR be returned after 3 months. By the way. Interim orders, if any, stands vacated.
22.
What is this?
IA is for condonation of delay.
And service?
Service complete, the respondent had filed Wakalatnama, then the engaged counsel had drawn the Wakalatnama, and this information was
How much is the delay?
1322 days.
What is your ground?
I was not aware about the final judgment, but I had explained in my statement is made in my
This type of grounds this court does not. Only Supreme Court can help you. Can't blame your lawyer.
but it is a reality, Lord.
So what? What have you taken? Have you moved the bar council?
Bar council, verbally complaint was made to the local bar.
What?
Regarding this delay, regarding information that verbally, I have communicated to the president of the local bar association.
Verbally doesn't work. You should have moved the bar council. This can't happen like this.
What should be, sir? A condonation, I am not arguing much more on this subject. Because the
Huh?
delay- Earlier condonation is the purely discretionary power of the honorable court.
Absolutely.
I'm leaving at the mercy of the court since
Yes.
2019. So since 2019, there is a lots of up and down. The private respondent received the notice. She has filed the wakalatnama. She has withdrawn.
I'm not concerned with the private respondent. Here is a case where the delay is not successfully explained. Now, this is an application under order 41 rule 3A, read with section 5 of the Limitation Act 1963 for condoning the delay of 1322 days in preferring the accompanying second appeal against the judgment and decree dated 16/5/2015 passed by the learned civil judge at Gwalpara entitled Appeal number 12/2015. I've heard Mr. F.Z. Mazumdar, the learned counsel, appearing on behalf of the applicant. None has appeared on behalf of the respondent. The sole ground which have been taken out here in the application is that the applicant, pursuant to receipt of notice entitled Appeal number 12/2014 from the Court of the Civil Judge at Gwalpara, applicants have engaged the counsel footstep. Thereupon, the said title appeal so filed by the respondent herein was allowed, thereby setting aside the judgment and decree dated 16/9/2016 passed in title suit number 42/2012 on 16/5/2015. Thereupon, it has been further stated that the applicants could come to learn about the said judgment and decree on 1/5/2018 on their own source, and pursuant thereto, the instant appeal was preferred. There is no explanation as to why the applicant did not have any contact with the engaged advocate for almost 3 years, or for that matter, during the period when the appeal was pending. There is no mention as to how the applicants could come to learn about the order, judgment and decree passed on 16/5/2015 entitled Appeal number 12/2014. Under such circumstances, this court is of the opinion that the applicants have failed to disclose any sufficient cause for condoning the delay of 1322 days in preferring the accompanying second appeal against the judgment and decree dated 16/5/2015 passed entitled Appeal number 12/2015. Accordingly, the instant application stands dismissed. Next paragraph. Taking into account that the instant application has been dismissed, the accompanying appeal, which had been directed against the judgment and decree dated 16/5/2015 entitled Appeal number 12/2015 by the Court of the Learned Civil Judge at Gwalpara cannot be entertained as it had become barred by limitation.
One more thing, Lordship, already this dismissed, but one factual that I was in touch with the lawyer. He did not inform me about the outcome of the fire. But during throughout this period, from my side, I have contacted him.
Where is it mentioned?
It is not mentioned, but it is also not
Very
mentioned,
well.
right?
Next.
Obliged.
Yes, what mistake have I done?
Of R.S. Chauhan,
Oh, this one.
out of state, your lordship.
Have you thrown them out from the forest?
Lordship, that I have to.
Throw them out. Then there will be urgency. Otherwise, they are keeping the review matter pending. Throw them out. How many months, years you want? Time. You only want time in this matter. Months.
Weeks, 3-4 weeks.
This is yet another. We have filed the affidavit. This is yet another occasion by which the petitioners herein seeks for an accommodation. In as much as on various occasions the review petitioner have taken time. The conduct on the part of the review petitioner to delay the disposal of the review petition in spite of there being a specific order on 12/2024 is reprimanded. Be that as it may, this court for the ends of justice adjourns the matter to be listed again on 10th of September 2024. It is made clear on that date, if the review petitioner again seeks for adjournment, this court would construe that the review petitioner is not interested in the review proceedings. Mr. Bhattakur, show them out. Yes, what is this?
Please, Your Lordship. So, ma'am, for the respondent number 2, Lordship. Lordship, as per the order dated 03/05/2024, Lordship, Learned Counsel for the appellant has issued notice for the withdrawal. Therefore, the applicant has received.
Yes. This court, by an order dated 3/5/2024, made it clear that if the applicants are not represented, the instant application shall be dismissed for non-prosecution. Today also, none has appeared on behalf of the applicant. Under such circumstances, this court dismisses the instant application for non-prosecution. That is 3072 দিব হয় এটো ও 3073 কব in view of the dismissal of IA number 3072/2022 for non-prosecution, the instant application cannot be entertained, for which the same is also rejected. Then Honor dismiss. এখানে দিব 4311 খন দিব. It's the matter on 19th of July 2024. First, it is made clear if the applicant is not represented on that date, the instant application shall be dismissed for non-prosecution. Yes, you have not been able to serve.
I have already been served, my lord, on 20 September 2000 as per office notice there.
And what is this type of
But
violence?
not answered has been guided.
As your has been received from your steps for service upon the respondent has not been received in the concerned section till date. What is this? And neither answer notice here, notice service is not complete. Huh? Service not complete. Best steps. Ms. A. Gain, the learned counsel appearing on behalf of the appellant seeks a further opportunity to take steps by way of registered as well as usual upon the sole respondent. 3 days time is granted to take such steps by way of registered as well as usual upon the sole respondent. List the matter after completion of service upon the respondent.
My lord, there's
Same order passed earlier. Will it stay? I condibo. The interim I 748/2000. One any the interlocutory application order, the interim order passed on 23/2023 is extended till the next date. Did I fix a date? No.
yes, I'll within 3 days. I will
It is extended until further orders.
ask the lord.
26 and 27.
One day's time to file the affidavit. It's ready, my lord. I will be serving it right now, my lord. Just now I got it from the department.
What have you done?
That additional instruction, my lord, whether they have got the authority, there is a commissioner who gives us instruction regarding my lord service conditions.
Why is it taking such a long time?
My lord, my fault, they have sent it, my lord. Now, my lord, additionally, that paragraph was to be
You
added, my
must
lord.
have thought that I am taking up bench 1, so I have no jurisdiction. As it is a bench 2 or 3 matter. So bench 3 matter, this court number 17 has no jurisdiction.
Not that, my lord.
Yeah?
Somehow
But you are not taking anything actively.
I will be filing it. Just now.
They have an urgency. He has now demoted. He ought to have been promoted.
He was already holding, yes. In fact, my lord, similar matters are also pending, my lord, because of this issue. If it is settled, my lord, they will cover their cases. Same issue is going on, whether it will be graduation or, my lord, high secondary.
Hello, how much time?
My lord, Friday also, nothing there, my lord, only that 3 or 4 documents.
Mr. B. Gogoi, the learned standing counsel of the
Next taxation department.
Finance and Taxation Department, submits that he needs a week's time for filing their affidavit in.
I'm appealing for the state of Assam.
Wait, let me conclude. The affidavit in opposition,
So additional affidavit.
the additional affidavit. List the matter again on 23rd of July 2024. The affidavit be filed without fail by 30th of June by 29th of June 2024. The petitioners, if so advised, the review petitioners, if so advised, would be at liberty to file their reply. Mr. K. Bhattacharya appears for the government of Assam. Will dispose it of 23rd.
28.
What is this FAO? Why the originals have been called?
That has been returned by last order.
Very well. Original has been returned. Okay, very well. Now, what is this FAO business?
Well, I have challenged an order whereby my lord injunction was rejected, not granted, my lord, in my favor by the proceeding under Land Grabbing Act. So what happened, my lord? I initiated the proceeding and notice was served upon respondent number 1. There were 2 respondents.
How are you filing an appeal?
An appeal lies, my lord, under that.
Appeal lies to where?
It's an order, order 39.
Understood.
I filed a petition injunction.
Understood. But if the
petition.
appeal does not lie,
No, application there, my lord.
you filed it before the special tribunal.
Yes, an application.
An appeal lies to where? An appeal lies under the special tribunal to
Appellate
where?
tribunal is there.
Appellate tribunal. Now the appellate tribunal is not there,
Okay.
so we exercise 227. Now, if an injunction is not granted there, and otherwise an appeal lies to the special tribunal and the special tribunal is not there, then where do you go? Yeah. But where, under what? 115 or 227? Why FAO?
My lord, I have filed FAO, my lord, because I have filed the petition, injunction petition under order 39 rule 1 and 2.
Fantastic, you have done the right thing there.
Yes, my lord.
But the question is that if appeal lies to a tribunal, appellate tribunal, and the appellate tribunal is not there, then under such circumstances, would an appeal lie to the High Court? Let us be more enlightened on your what you thought. Let us also, for me, I think the High Court cannot exercise the power of appeal.
I have filed it under order 43, my lord.
Fantastic, you lightly done it, or taking it in account that it is an order passed by the but it is a special tribunal. If it is a special tribunal, can you move under by filing an FAO? Otherwise, when a decision of land grabbing is given under the first provision, there are 2. One is the civil and the other is the criminal. The civil, we could have taken it as an RFA. Can we take it?
My lord, that is the-
Because the appeal doesn't lie to us.
but,
Therefore, we exercise 227. Similarly, in that case, if an appeal does not lie under order 43 rule 1R here, because obviously this is not an order under 104 for us. Think, we'll have it some other day.
in the meantime, my lord, by last order, I was asked to.
In the meantime, we
Madam.
will, I have to proceed, I'll have to dismiss.
Okay.
Think about it. Did you get any order here?
But there is an interim order, my lord,
Eh?
by order dated, my lord, 7/8.
Hey.
That may kindly be extended, my lord, till night. So they are trying to construct over the land that I own, my lord. Despite having notice from the learned tribunal below, they have
What are
not
they
expressed-
constructing?
But presently, my lord,
A notice has been issued.
notice was issued. I was directed to take dusty. I have taken and yesterday.
No, the injunction proceeding is pending.
Yes, notice was issued.
We convert into 227 and ask them to dispose of. You are appearing there?
Yes, my lord.
There?
Because the case was stayed, my lord, that was, I could not appear.
Are you
Yes, yes,
appearing there?
yes, my lord.
Fantastic. Both of you go and fight there.
But there is another one respondent, my lord. I have taken Dusty, he has not appeared.
Not necessary. This injunction orders will status quo be maintained till the disposal of that injunction application.
Yes, my lord, yes.
That's all.
I'm appealing on respondent one, my lord.
The instant appeal is filed under Order 43, Rule 1R of the Code of Civil Procedure 1908. Being aggrieved by the non-granting of an ad interim ex parte order of injunction by the land grabbing case special tribunal Kamrup Metro at Guwahati in Miss Case number 75/2023. The order, no doubt, is an order passed in the proceedings under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure 1908. However, the said order was been passed by the order dated 21/6/2023 is an order passed by the Special Land Grabbing Case Tribunal, Special Tribunal. Under such circumstances, an appeal does not lie before this court under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure. As the said order is not passed by a civil court but by a tribunal, wherein there is an appeal which lies before the appellate tribunal but yet to be constituted. Under such circumstances, this court converts the instant proceedings in the interest of justice to a proceedings under Article 227 of the Constitution. Next. This court have been duly informed that the respondents have duly put in their appearance before the before the learned land grabbing case special tribunal.
Respondent one, my lord. Two,
You are here, not there.
I have no idea about two, my lord.
In Miss Case number 75/2023. Under such circumstances, this court is of the opinion that continuation of two parallel proceedings before this court as well as before the learned land grabbing special case special tribunal would not be in the interest of justice. Under such circumstances, this court directs the learned land grabbing case special tribunal to take immediate steps for disposal of Miss Case number 75/2023 by hearing the parties to the said application so filed under Order 39, Rule 1 and 2, read with Section 151 of the CPC. Taking into account that this court, by an order dated 7/8/2023 in IC number 2240/2023, have directed the parties to maintain status quo over the suit property and also clarified that no construction activity shall be undertaken by any of the parties. This court directs that this order shall remain in existence till the disposal of Miss Case number Miss case number 75/2023. Which arose out of
Land grabbing case number 31 of 2020.
land grabbing case number,
31 of
special land
2020.
grabbing case number 31/2022. Good stop. This court, however, makes it very clear that the learned land grabbing special tribunal, while disposing of the miss case number 75/2023, shall dispose the same on its own merit without being influenced by the order past hearing. Dispose false return.
In the petition and the respondent lordship, and the entire amount was settled at 14 lakhs lordship. And the respondent has already paid an amount of rupees 7 lakhs to the petitioner lordship. And upon her failure or non-appearance, the 7 lakhs was pending before the party. And lordship, and subsequently he had to withdraw because he didn't appear. He failed to appear in the family court lordship. And upon that, he has again contested the case and filed a divorce case. And now he is subsequently filing some medical documents lordship. Now I have taken instructions from my client also lordship. Her father is running a nursing home lordship, and she is currently working there.
Nursing home?
Other I don't know, but see,
So what? You categorically say that you are relying on the money from your parents. Well, so this is a double-edged sword, Mr. Gupta.
my father may be,
But you say that you are getting all the money from your parents.
because this petitioner is
Your
suffering,
father has good amount.
this petitioner is suffering from cancer, man.
Who?
Petitioner. I have annexed the medical documents, my lord. She is under treatment, my lord.
But subsequently, lordship, they've concealed the fact that they've already received 7 lakhs from us, lordship.
And my lord, the earlier petition filed for divorce was dismissed for default, my lord.
Subsequently, lordship, a mutual divorce proceeding has also been initiated, lordship. Because the talk of amicable settlement has already been taken place, and the petitioner has already received an amount of 7 lakhs from us, lordship. That has been concealed in the petition, lordship. That is why lordship may kindly give a chance to file my written objection so that I can put the materials on record, lordship. Because all
She's
the
suffering from-
witnesses are also from
But
Guwahati,
madam,
lordship.
she is suffering from cancer.
Lordship,
Had to come all the way.
lordship, all the witnesses are from Guwahati also, lordship. Otherwise, lordship may kindly send the
You do
matter
one
to-
thing, very well. You give her a flat out here. And also maintenance of 25, 30.
Lordship,
What
in
do
the
you do?
125, lordship, earlier I was practicing in Delhi, but right now I'm unemployed, lordship.
You are a doctor?
Practicing in Delhi, but currently I'm
What were you
unemployed.
practicing?
Currently I'm unemployed, lordship. I'm staying in
Understood.
Guwahati, lordship.
What practicing? What were you practicing in Delhi?
Pharmacology.
Do one thing, give her a flat out here on rent.
Lordship, subsequently says
30,000 on that and 55,000 for monthly expenses, 85,000 till the divorce proceedings are over. Yeah.
Lordship, in
You'll
the
be-
125 petition, lordship, the court bill was
85,000?
already granted 10,000 and I'm paying that, lordship.
Nothing doing.
125
She has a
proceedings also.
divorce. She's suffering from cancer. How will she come every time here? It's a very difficult thing.
Lordship, may kindly send the matter to the mediation, lordship.
For what?
Like the talk for amicable settlement, the matter may be settled, lordship.
You don't want a divorce? You
Because
don't want a
already a
divorce?
mutual divorce has been initiated earlier.
They are living separately from,
Why don't you go for a divorce? If they don't want,
but what happened?
you ask for whatever alimony, it is different.
What happened, my lord? Earlier also, my lord, the husband has filed one divorce petition at the family court, my lord. Petitioner filed transfer petition, then it was transferred to Dibrugarh, but he has failed to appear there, my lord. Thereafter also, my lord, one mutual divorce petition was filed.
Why does he have to appear? He can appear through his lawyer.
Lordship, the main crux of the facts is that in the mutual divorce, we've already paid 7 lakhs. Only 7 lakhs out of the entire settlement amount, only 7 lakhs was pending to give. But due to the failure of our non-appearance, Lordship, I had to withdraw
Why
the
didn't
case.
you ask for restoration of the divorce proceedings instead of filing another one?
Lordship may just give 1 week time, Lordship. Because today my senior is also out of station. Your Lordship may kindly accommodate me for the
Who is
day,
your
Lordship.
senior?
Mr. MK does, Lordship.
MK?
Does. Lordship may kindly accommodate me for the day, Lordship.
Okay. Should I not transfer this? Then
the
you
discretion
ask
of-
your client to be ready with 85,000 monthly.
Lordship, this is the discretion of the court, Lordship.
No,
Lordship
no,
may kindly
that is not a discretion. That is, I'm putting it on order. If you are not 85,000, 30,000 for house rent, 5,000 for month. Instead of getting the money from your father from the nursing home business,
Lordship is working in her father's nursing home as per the instruction of my client, Lordship. Lordship may kindly accommodate me for the day, Lordship.
the counsel appearing on behalf of the respondent seeks for an accommodation. File a reply. This court had specifically inquired with the learned counsel appearing on behalf of the as to why a reply is required to be filed. It has been submitted that the petitioner herein, though resides at Dibrugarh, but she is duly working in the nursing home belonging to her father and is earning a good livelihood. Taking into account the above, this court adjourns the matter to be listed again on 19th of August 2024. The respondents would be at liberty to file their reply by 12th of August 2024. In addition to that, the petitioner shall also file an affidavit stating on oath as to whether she is earning any livelihood out of the nursing home business of her father. In time or the party shall continue.
Obliged, Lordship.
Item 41.
Yes, what do you have to say?
My lord, application file lordship.
The originals are with you, Annexure 11,
The
Annexure
original
Roman 3.
lordship that original lordship as per the plaint lordship, I have stated that the tenancy started from the year 2009. But whether the originals is with me, that statement is not there in the plaint. Now, in the written statement, it has been stated that the tenant has a photocopy of it, but that exercise could not be completed at that point of time. Now, after that, an application has been filed. After around 5 to 6 days taking time for filing DWs, in the month of November, one application has been filed under Order 11, Rule 14. Now, the order, if your lordship would see,
Have you given is a DW?
I have already given my statement. I am for the
No, what is the stage of the suit now?
for DW, for filing of DW. I have already given my PW lordship.
Okay, you are the plaintiff.
I'm the plaintiff.
He is asking for this document.
document.
Now, if we read order 11 rule 14, it says at any time of the suit, can very well file. Now, do you admit to the contents of this document annexure Roman 3?
That lordship that is the exercise which has to be carried out by the trial court under order 11 rule 1 and rule 12 lordship. Now, if that exercise was carried out, then then after that, if 14 it was invoked, that's a separate issue. But now,
No. The trial court rejects it because you admit the document.
no lordship.
Yes.
I have never admitted the document, lordship.
What does the order say? Upon perusal, it transpired the agreement is not the matter of dispute. In this case, as both sides have agreed, the tenancy array was executed on the year 2009.
Yes, lordship. The tenancy is of the year 2009. That is not in dispute. I am also not denying that. But with regard to as to whether the original is with me or it is not there with me, that exercise has not been done by the court, lordship. No?
So under such circumstances, the court ought not to have rejected this. Court should have asked you to produce it. If he had not, then he would have produced the secondary evidence.
No, that exercise under order 11
What
rule
about
12,
order 11? He has done under order 11 rule 14.
14,
If
lordship.
you don't produce it, he has stated it is with you. If you say that you don't have it, then he will take the appropriate steps for giving secondary evidence.
There for secondary evidence.
Well,
Yes, so if your
the
lordship,
court should not have done that. Interfere with this order and directing that we have to decide that the application afresh as to for calling for the originals of the year and thereupon to decide.
yes, lordship, that is my humble assumption, exactly, lordship. Order 11, 1 and 12 has to be completed, then 14 is
I do is order 11 rule 1. What is order 11 rule
rule
1?
12, lordship.
Then
Rule 12 has to be done. After that, 14 if that's the
why
difference.
14? Why
14
order
they have filed an
rule
application.
11 12? Order 11 rule 12? One can
Because-
very well go under order 11 rule 14.
Because in the plaint, lordship, I have not stated two things, lordship. In the plaint, I have not stated whether.
As he stated in his written statement that their document is with you.
Yes, Lord. They have stated, but
So he has done in terms with order 8 rule 1A.
my humble submission is that, lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf. And Mr. So-and-so, the learned counsel appearing on behalf. The instant application has been filed challenging the order dated 15/2/2024 passed in title suit number 9/2019, whereby the learned trial court, that is the court of the civic judge, junior division number 2, Karbi Anglong Difu, had rejected the said application filed by the petitioner who is the defendant in the suit. Under order 11 rule 14 for calling for the originals of the agreement dated 22/1/2009 or to allow the defendant to lead his evidence on the basis of the photocopy of the agreement dated 22/1/2009 as secondary evidence. It is seen that the respondent herein, who is the plaintiff, had filed a written objection through its advocate. Be that as it may, the learned trial court by the order dated 15/2/2024, rejected the said application on the ground that there is no dispute as regards the agreement of tenancy dated 22/1/2009. Inasmuch as the main dispute in the suit arises as to when the defendant stopped paying the rents after July 2018.
This tenancy is with respect to agreement of 2016, not 2009. Same statement.
Where is your written statement?
Statement in page number 13 lots. 10E lordship, page number 15. 10E. Yeah, next is the WS logs.
This court have duly taken note of the written statement filed by the petitioner herein, wherein in paragraph number 10A, he categorically mentions about the agreement dated 22/1/2009. In addition to that, in paragraph number 28, it has been also categorically mentioned that the original copy of the rent agreement dated 22/11/2009 and 11/8/2016 are in the custody of the plaintiff. Specific leave was also sought for by the said paragraph for the calling for the originals of the two agreements dated 22/11/2009 and 11/8/2016 at the time of evidence. It is in consonance with the said, the application was filed under order 11/14. The learned trial court, however, rejected the said application on the ground of relevance without the said document being brought on record. Under such circumstances, this court interferes with the order dated 15/2/2024 and directs the learned trial court That is the Court of the Civil Judge Junior Division number 2, Kamri Anglong and Difu, to decide afresh the petition number 401.
Lordship, on the day of filing evidence, Lordship, I discovered that this document was not there.
What is 471?
So 470 was subsequently for alternate, adding alternate prayer, Lordship, I filed.
No, what is this number? It is 401.
Terms were filed with the same prayer, Lordship. One on 29/9/23 and another one is 7/12/2000. Same prayer, Lordship.
Of 401/2023. I think this is 401 and excess 6. So we direct only 401. Yes. Upon after duly taking note of the observations so made, with the above, the instant petition stands disposed. The parties who are duly, the parties have duly informed that the next date fixed before the learned trial court is on
21/6, Lordship.
21/6/2024. The learned counsel appearing on behalf of the petitioner is directed to place a copy of the instant order before, certified copy of the instant order before the learned trial court for further proceeding of the suit.
59.
Mr. Pinakaka, this is the case where you need to lose a battle to win a war. He wants that document, he does not want that document has no relevancy, and you have unnecessarily spent 6 months or 7 months now here, unnecessarily. He should be allowed. While practicing in the civil court, I realize one thing, small matters you need to give it out, otherwise it comes out here and it only delays it.
Hello.
59.
The last order, we have taken justice services is completed.
Service is not complete
And
upon 111213.
as per the last order method, we have taken justice service because Tenant is appearing.
You are appearing for 111213.
All are responsible.
LCR has not been received. LCR has not been received. No? The service is complete, however, the LCR is not received. The registry shall take appropriate steps for requisitioning of the LCR at the earliest to establish the matter for hearing immediately pursuant to receipt of the LCR. The council, the parties are given the liberty to file applications for early hearing of the matter.
Case 24,
Yes, what is this?
readmission of the appeal.
Fees for default. Delay.
There was no delay.
Then what is this? So many miscases.
So many mistakes in other cases, like substitution and bill payment and lot of. Case 24 for readmission of the appeal. Explanation in paragraph 2.
Where is the, which one?
This case 24.
$26.
4.
My goodness. It's on time.
On time.
Why was it dismissed?
My name was wrongly reflected, my lord. Therefore, I missed the case, my lord.
Huh?
Explain in paragraph 2, my lord.
Where is the order of dismissal?
Page 9, lord.
How many Siladittas are there?
I
With the
charge,
spelling.
no, my lord, when I search the keyword, my lord, it doesn't-
You put the keyword. Yes. You are the only counsel who writes Siladitta only.
Right.
Then there cannot be another one,
charge, my lord.
isn't it?
In Wakalatnama, my learned friend signed the Wakalatnama SHI, but in the petition para 2, my learned friend has mentioned SHEE. Lordship,
It is the name
I
of
have
the-
no objection for restoration. It may be restored, but such type of frivolous petition should not be filed. I have no objection
In fact,
because
my lord,
Lordship may be pleased to pay my affidavit in opposition. In the an earlier last page is the Wakalatnama file my learned friend, where he has clearly signed a SHI. But in the petition, Lordship restoration petition,
the name itself is
Page-
SHEE.
last page of my affidavit in opposition, Lordship, SHI, Siladit.
SHEE.
Double E. He writes like
The
that.
point is there.
Oh, he signs. It's double E only. Anyways, he
may be
can't
restored.
take that excuse.
It may be restored.
Chalo, we impose a cost of 5,000 upon the lawyer.
But before RSA record reveals on sale, so on earlier many dates in RSA, my learned friend did not appear.
Only this reason, my lord, because the name wrongly shows, my lord. I will
No,
not-
no, no, don't come up with this silly excuse. You can't take this court for a ride. 50,000. 1,000
It's my,
on you. You are the person who filed the affidavit.
it's kind of legal aid to my client, my lord. He's even not even able to pay the professional fees, my lord.
You're doing legal aid.
Like a legal aid.
Show me where have you stated in the affidavit.
The
If
application.
he
is
wins the
filed
case, what is he going to get?
with, title, my lord.
Then, why you're doing legal aid?
Poor fellow, my lord, he cannot afford, my lord. That's why.
Nowadays we got good lawyers.
The application which I have filed, my
Then
lord,
is that the reason you didn't appear on many occasions? That's the reason, because the order by which it has been dismissed for default shows that the earlier IAs have been also dismissed for non-prosecution.
the same application has been filed, because the reason is that, my lord, name has been wrongly shown, my lord.
No,
That's why-
no, don't come up with that silly excuse. Go to Supreme Court. That is the ground you are taking. Go to Supreme Court. Supreme Court may think what is the difference between I and double E. Go to Supreme Court. Pay cost of 10,000 to somewhere good place.
My client not able to pay.
You. No, I'm not imposing your client to you. I'm imposing upon you, not to client. As you are doing social service, do some more social service to other people which is the best place to send. Yes, you are a social welfare council. Tell me where to send. Some Shishu Niketan or something out there. Better na? Do more social service. 10,000 for each application. 10, 10, 10, 20, 30. 30,000.
I am not able to pay, my lord, because
Absolutely no. This is the encourages the grounds which you have taken. No. I'll make it very clear. I'll see it from the affidavit. All orders, it has been shown as SHILADITY. Everywhere.
and,
Everywhere it has been shown. Earlier, you didn't complain in respect to the instant matter when your name has been reflected as Siladitta. And now you are making all these things. There has to be a more ingenious approach. Not satisfied. Dismiss it. Better. Go to Supreme Court. Oh, this is an application for restoration of the RSA number 226/2014, which was dismissed for non-prosecution on 16/2/2023. The application has been filed on time, but however, the reason which have been assigned in the instant application by the lawyer does not inspire the confidence of this court, taking into account that in all orders passed in the instant proceedings, his name has been reflected as SHILADITYA and not SHEELADITYA. Under such circumstances, this court reprimands the conduct of the counsel in filing an application in such a manner. Be that as it may, taking into account the interest of justice, this court restores this court, taking into account the interest of the appellant, who would be prejudiced on account of the fault of his counsel, allows the instant application. Thereby restoring the RSA number 226/2004, thereby recalling the order dated 16/2023, passed in RSA number 226/2004 and restoring RSA number 226/2004 to the file. I stand exposed. What is this 2026?
There is substitution application also.
This is also Siladitya.
Yes.
Same now. Okay. Restore reprimands. 23, reprimand. 22, reprimand. But these were much delayed.
A delay application was there.
Then, like you can reprimand, delay is there. How much delay? Ayebu delay niki. Delay kung panas.
The application is IA 950/23.
That is for
So this is for deferment of one substitution application matter.
IA for restoration of IA.
IA.
Filed for substitution. Then
my lord, IA 876/23, my lord, that is for delay confirmation application. This is on substitution. IA 951/23. Then this case, my lord, 26/23 for substitution. 23 and oblique 23.
Delay condonation. Yes, what do you have to say?
Be allowed. Delay is 114 days.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. Espiroy, the learned counsel appearing on behalf of the respondents. An application, this is an application for condonation of the delay of 114 days for restoration of IAC number 1770/2022. The explanation so given in the instant application by the council. Oh, delay, how can you file? How can you file delay?
Before
How can you file a delay application? You can file a restoration. How can you file a delay? You can't swear the affidavit. Any? We can't do that.
it was most probably swear by the petitioner.
Absolutely no. That is again with Siladitya as LEEE. Then all these affidavits are done by you.
I have filed my affidavit in opposition.
Now, he cannot do that.
No, cannot.
You cannot file a delay application. You may file a restoration application, that is permissible, but how can you file a delay?
In substitution.
Now, delay of restoration of the substitution, can you file a delay?
But only the question of knowledge of the parties, lordship, advocate
Because
cannot.
knowledge derived from me, my lord, because my name was not reflected. So facts were, my lord, in witness.
Your name was properly reflected. Only your name everywhere.
Wrongly
Not wrongly reflected. That is the name you have. You change your name whenever you feel like. There's only one name which is being mentioned out there in the cause list, Siladitya, that is you. You don't look into it. And how do you appear in all other matters?
This time is SH double E, my lord. I searched the keyword is.
Where is
SH
the
double E.
cause list?
Yes, today itself also, my lord, it was came as SH double E, my lord.
Today it has come as double E.
SH,
And at that point of time,
SH, when in the
where is
order,
the cause list you have enclosed?
in the order sheet itself, my lord, this was reflected as
Where is the cause list you have enclosed that day?
was not included.
Oh,
Because
no. Go order, not done.
even in the order sheet, my lord, name was.
The counsel appearing on behalf of the petitioner. The counsel appearing on behalf of the petitioner shall bring on record the cause list of the dated 16 to 2023. By way of filing an affidavit. Is a stay or stay has been vacated?
I'm the plaintiff. I'm the plaintiff. After vacation, lord.
You file whenever you may file after 10 years, that is your lookup. You may again search your name.
Obliged, lord.
30.
Lordship, in this case, like, and I'm sorry, Lordship, as the sole respondent,
What is this, madam?
I'd say Lordship,
IA for what?
I have for Lordship, detail Lordship,
How much?
85 days Lordship.
119. How much is the delay? $119 days delay.
My lord, the name of Mr. A. Sattar is wrongly shown in the causes, my lord.
Huh?
My lord, the name of Mr. A. Sattar may be struck off, my lord. It is wrongly reflected in the cause list, ma'am.
Now service?
Lordship, and notice has been answered.
Name has been struck off the name of here. Notice have been issued to the sole respondent by steps by usual post have not been received by section 20. Service not complete. The office note dated 23/4/2024 shows that the service is not complete. Accordingly, list the matter after completion of service.
My lord,
It is IA 201618.
my lord, if I may, I pray for the name of Mr. A. Sattar to be struck off.
It's already been
Yes.
struck off.
Highly,
I can't help it.
highly.
The name, already there is an order.
Yes.
Apply.
I is for condonation of delay lordship notice already issued and all the respondents received eviction.
For condonation of delay, others have received.
Yes. Our office note dated.
How much is the delay? Hello, we condone the
17.
delay. Service is complete upon others.
9/11/2000.
This is an application filed under Order 41 Rule 3A of the Code of Civil Procedure, read with Section 5 of the Limitation Act 1963 for condoning the delay of 78 days in preferring the in filing the accompanying regular second appeal directed against the judgment and decree dated 19/12/2022 passed in title appeal number 15/2020 by the learned court of the civil judge Borpeta. Full stop. It is seen that the service upon the main defender respondents have been duly complete. However, none has appeared on behalf of the said defendants. Be that as it may, this court, having taken note of the grounds which have been assigned in the instant application, is of the opinion that the applicants have duly explained, the applicants herein have duly explained, have shown sufficient cause in preferring the delay in preferring the accompanying second appeal. According the delay stands condoned. The registry is directed to register the accompanying second appeal and list the matter under Order 41 Rule 11 of the Code immediately after the summer recess.
Obliged.
I stand dismissed.
For condonation of delay, but as per office note dated 15, service on respondents are not complete. Lordship.
Complete?
Not complete.
I am for 224 and 11213.
Who is one?
One was the original respondent. Look.
How are you connected with one?
Because they are the legal.
One, somebody has appeared, 1A, 1B, 1C. 224, who is 5?
I is complete. Lordship.
Who is 5? Anywhere connected with Mr. Sahu?
No,
Who is 5?
That's Sahid,
And how much is the delay?
475.
Okay, we dismiss it. Why should we go into all these things? Service has not been able to be completed. Dismiss it. Don't take all this pain of affecting against service. Why do you spend unnecessary money?
It has been explained.
So what? You have blamed your lawyer. Then what is the other ground?
Para number 3, Lordship.
What is your ground?
Ground is that the second appeal is pending before this honorable court for final disposal. In the meantime, the respondent number 1 has died, but that fact was not informed to the lawyer. But whenever they in 2023 came to inquire about the
matter, then during the conversation, they informed that respondent number 1 died.
Then
The lawyer advised them to file the fee application. Okay?
this is for what? IA for
For condonation of village substitution.
substitution?
Yes.
Okay. Who is appearing for respondent number 5 earlier?
Earlier also perhaps not.
He was proceeding ex parte. Who was appearing for respondent number 5? And why do you need the performer respondents?
But the respondent 5 is the main respondent. In
Yes,
the
main one is 5. And
It's not. It's
there's a stay, Mr. Sahu.
Look.
Stay.
Perhaps, Your Lordship. No, because
finding,
they were the plaintiff, they have come.
So you're a plaintiff. So you have no urgency. Okay, fantastic. The office note shows that the service upon the respondent number 5, along with a host of performer respondents, are not complete. It's the matter after completion of service. I couldn't live 2815.
apply.
Yes, you have received everything. The BKJ hearing on behalf of the review petitioner submits that the review petitioner have received and the entire amount, and as such would not further press the instant review petition. The GC Bora, the learned standing counsel of the ASTC, submits that the all amounts have been duly paid to the review petitioner. Taking into account the above, the instant review petition is closed. Yes, what is this?
Also, this review petition has been filed against the order dated 1811.
Ah,
Lordship, the scheme under which the respondent has done the work was a central and state government.
yes, you are appearing.
Lordship, I am paying, Lordship. As per
For?
the petitioner. Lordship, I was the petitioner in the writ petition, Lordship.
What has happened? What is the mistake we committed?
Lordship, not
Oh, there is
mistake.
a direction be given out there for the purpose of making them a party, the direction.
Yes, Lordship, Ministry of Jal Shakti, Lordship.
Without the Ministry of Rural Affairs, it is difficult.
Jal Shakti, Lordship.
Huh?
Ministry of Jal Shakti, Lordship.
Without Jal Shakti, you cannot comply.
Yes, Lordship.
Then why didn't you inform this court at that point of time?
Point of time I was unaware, Lordship.
Is he entitled to the amount?
Yes, Lordship.
Have you stated on affidavit? File it. Counsel appearing on behalf of the respondent, appellant, review petitioner shall file an affidavit as to whether the petitioner is entitled to the amount of rupees 24,99,741. After the verification which this court had directed to be carried out by the Chief Engineer, Water Resource Department, Chandmai. List the matter again on 22nd of July 2024. Once it is being done, then we will take appropriate action.
Published.
Yes,
Your Lordship, I had taken steps. However, Your Lordship, I apologize that we could not take steps to justice. By paying the at least a
service
week's time may be granted to me. Your Lordship.
for
I've
what?
taken steps for dusty service, Your Lordship. I've
You
taken.
have not taken. There was a direction I gave you
Yes,
an,
yes.
yeah, the stay, I
Yes.
you have not, we vacate that order. Immediate.
A week's time, Your Lordship.
No, sorry. This is a long term order you have been taken, you have not taken steps by way of justice.
I apologize for the.
Yes. Can't help it. Is he your not brother?
No, your lordship.
Who is he?
A different person.
And the suit is pending?
Yes, your lordship.
What has happened to the suit?
It's still pending. They have not appeared. They have not appeared, your lordship.
So,
I'm only paying for a week's time, your lordship.
no, nothing doing. I'm vacating that order. You gave all the address which is wrong. Sorry. Keep it. Dismissing your appeal. What is the next date of the suit?
22 August, your lordship. 22 August.
22?
August 2020.
What happened on 21?
They didn't appear, your lordship.
Huh?
In stepped upon them, they didn't appear.
They have not appeared. Then? লেখক এখনো লেখক IA 1380/2024. This court, by an order dated 17/5/2024, directed this court, by an order dated 17/5/2024, though passed an injunction order, but inadvertently did not issue any notice the instant application. Is directed to the appellate court, therefore. Now, you have not been able to communicate this order to the other side.
Yes, your lordship.
Have you?
No, your lordship. I have not been able to communicate. Your
Then
lordship.
what is the sense of this order?
It's only a week's time, your lordship. Week's time, your lordship, to
For what?
for dusty service, your lordship. For dusty service, your lordship.
No, you have not taken steps. I gave you on 17/5, today it's 6.
I agree, your lordship. He was not well, your lordship. Considering that aspect, your lordship.
Sorry, Mr. Deori, I can't help it. You could, that person stop coming after this order?
They have not come, your lordship, after this order.
After this order, but before passing of this order, they came.
Yes, your lordship. After this order.
And
they-
you have not been able to communicate this order.
Yes, your lordship.
How? How did this happen?
I don't know, your lordship, but they had not come after this order.
This is too magical. You have not been able to communicate this order, but just before the order being passed, they have come.
To your lordship, they came, your lordship.
How do they know about an order being passed?
I am not aware of it.
You filed a suit also. Go there. Nothing doing. I protected you for some time because the next date is fixed on 21.
2 August, your lordship. So on that day, your lordship.
was fixed when? Before the learned trial court?
21/4.
Huh? 22/6. When is the next date?
22 August.
No, the earlier order.
The earlier order it was 6/6/2024. 6/6/2024. At page 96, Your Lordship, of my IA.
What happened on 6/6?
They didn't appear on 6/6, Your Lordship.
So, should we continue a parallel proceedings? If you have not taken service. Sorry. Oh. The instant appeal was filed being aggrieved by the order dated 18/4/2024 passed by the Court of the Civil Judge, Senior Division Number 3, Kamrup Metro at Guwahati, whereby the learned trial court only issued notice but did not grant the ad interim ex parte injunction, thereby fixing 6/6/2024 for service report / objection in Ms. J case number 357/2024 arising out of title suit number 195/2024. This court, taking into account the urgency shown, passed an ad interim ex parte injunction on 17/5/2024 in IAC number 1380/2024, thereby directing the parties to maintain status quo as regards possession of the suit land which have been specifically described as Schedule A to the plaintiff of title suit number 195/2024 till the next take, that is today. This court also had observed that the instant proceedings as well as the order passed herein shall not be a bar on the part of the learned trial court to proceed with the injunction application. This court further takes, while perusing the office note, it is seen that the petitioner, the appellants herein did not take steps by way of dusty as so directed. In addition to that, the addresses which were mentioned of all the respondent numbers 1 to 6 were insufficient addresses, and as regards 1, 2, 3, 4, 5, and 6 were insufficient addresses as has been mentioned by the process server remark. Further to that, in the service of through the service so try to be meted out through usual process, it has also been shown that the addresses of the respondent number 3, 4, and 6 were also not found. Under such circumstances, this court is not inclined to further continue with the another parallel proceedings before this court. That too, when the injunction proceedings are still pending before the learned trial court, that is in Ms. J case number 357/2024. Accordingly, the instant proceedings stands closed. However, this court makes it clear that the interim order so passed On 17/5/2024, in IAC number 1380/2024, thereby directing the parties to maintain status quo as regards possession of the suit land, which have been specifically described in Schedule A to the plaint of title suit number 195/2024 shall continue till 8/8/2024. That is the date on which the learned trial court had fixed the injunction proceedings. With the above, the instant appeal stands disposed. The learned trial court shall adjudicate the said injunction proceedings in accordance with law without being influenced by the orders passed by this court today, as well as the order dated 17/5/2024. Appeal stands disposed. I, so and so, stands closed.
I'm deeply obliged, Your Lordship. It is 22/8, Your Lordship, not 8/8/66.
22/8. But Mr. Deori, this court is very dissatisfied with your conduct. Next time onwards, you won't get an injunction. I'm taking it for granted. This is not what you expected from a lawyer of yours. Yes.
Restoration petition, my lord. My lord, the direction had been passed, my lord, to take steps, my lord, thereafter, my lord, steps.
Where is the order?
Order is at page 17, my lord.
Oh, none appears for a further to that on the earlier occasion, none has appeared. Then why should we? Nothing out there.
The fault of the, my lord, petitioner who was before this court, my lord.
Huh?
It was not the fault of the petitioner who was before this court, my lord. The basic, my lord, petition which was filed here, my lord, the cause was, my lord, non-acceptance of the statement.
I'm not concerned.
Yes,
We are not concerned with that. We are concerned with why the council out here did not appear.
my lord,
Not
I take
once,
it on
not
me, my lord.
twice. They were directed to take steps, nothing doing. You couldn't have taken things for granted. Who was the council?
Okay, Roy Chaudhary, okay.
Then can't help it.
Well, the client should not suffer, my lord, kindly consider, my lord. and
Hello,
is
we
that-
impose
is that
cost.
temporarily, my lord.
I'm one to suffer, that is his lookout.
Yeah, residents of Calcutta,
On
my lord.
request of via matters stands adjourned, service
Yeah,
is not complete, the
Sir,
office
give me
note
3
under
days time, my
survey
lord. Within 3 days, I'll take steps, my lord.
taken Iman. You did not take steps in spite
My
of
lord, give me
direction
3
being
days time,
given.
my lord, I'll take steps. This is my undertaking to the court, my lord.
Huh?
Kindly give me 3 days time, I'll take steps, my lord. Kindly restore it, my lord. Allow me to, my lord, press the main application, my lord.
Why? This was done recently.
My lord.
Cost. What is the suit for?
First for, my lord, a partition, my lord. Declaration of right taking interest and partition, my lord.
The written statement was not accepted.
Written statement was filed, my lord, beyond time, my lord. On the last date of 90 days, my lord, an application was filed, my lord, to accept it. It was not accepted. Thereafter, on the next date, the written statement and that, my lord, objection was also filed. But because of the earlier order, my lord, that was not taken on record, and when we came here, my lord.
Inspire a conference. We have to issue notice.
Restoration is between the court and the, my lord.
Absolutely no. Have a right to hear other side. And help it. Click on restoration. How can we restore without issuing notice? Tell me.
Restoration, in my humble understanding, my lord, restoration is between the court and the my lord applicant. My
Did
lord,
it happen without the dismissal, did the other side appear? And okay, then we can be. An application for restoration of for recalling the order dated 29/4/2024 passed by this court in CRP number IO number 427/2020, which was dismissed for non-prosecution on account of the failure on the part of the petitioner to take appropriate steps was for restoration of for recalling of the order dated dismissed for default on account of the petitioner having not appeared on 29/4/2024 when the matter was called. This court, having taken into account that taking into account the grounds stated, is of the opinion that that interest of justice could be met. Application is allowed thereby restoring the PRPIO number 427/2023. However, this court is also of the opinion that certain cost needs to be imposed. As much as the was duly informed by the order dated 1/4/2024 that the petitioner is required to take steps. Under such circumstances, this court imposes a cost of ₹11,000, which shall be deposited by the petitioner before the yes, madam. Social service?
Ashalai, my lord, let's go to Ashalai, my lord, say, he sent home.
Huh?
The orphanage, my lord, Ashalai, let him to Ashalai.
Asale?
That is taken care of by the selection sisters here, my lord.
Asale.
Ashalai. It's in Chanmari.
Address?
Chanmari. Chanmari, that Krishnanagar area, my lord, just below that Holy Child School.
Anything else? Shishu Nikiti? Shishu Saruthi, Shishu Nikiti.
Permanent. All the same.
Saruthi. Shishu Saruthi. I think it's office at. এখন লিস্ট এখন বানাবো cost will all will go now. Today I could see in Allahabad High Court and all this Bombay High Court they gave it. In one case, there was a judge who within 5 years could impose costs upon the litigants and deposited almost 30 crores. Let me also try to break that record.
No, my lord. Already your levels of, my lord, 1 lakh per day is causing, my lord, disturbance. Oh, my lord, kindly don't go to that level.
Yeah, Bombay High Court, they put 30 crores.
Bombay and Assam, my lord, is a far difference, my lord.
Tell more litigation. At least the one end of now, sub money will go. All this go to these non-government. Shishu Saruthi, just find out from there the address. Shall be deposited in the before the at the Shishu Saruthi and a receipt shall be placed before the registry within 4 days.
Can I then, my lord, replace the receipt before trial court, my lord?
No, this matter will come before this court. You want the restoration here?
Yes.
Why will you give it to the trial court?
That's all.
Before the registry of this court. So upon the said, the matter be listed the revision application be listed before the court.
That order was vacated, that kind of order be.
That will remain. Mr. You deposit
Let it be after 1 week, my lord. People are in Calcutta, my lord, from Calcutta.
in 1 week. In 1 week, and shall, so the matter, the CRPIO shall only be listed after the deposit of the said amount, a receipt of the said amount be deposited before the registry of this. And the liberty would be given to the petitioner to mention the matter, the accompanying CRP
In the meantime, my lord, the
revision
address of the
application
CCRP will be given by them, my
upon
lord.
payment of the after deposit of the after deposit of the receipt before the registry.
My lord, they will give me the address of the CCRP.
What?
Give me the
You
address of
find
the-
it out from the internet. They are also going to find it from the internet. You also find. Yes. Yes, what is this?
My lord, the person to order it 29/5, my lord. We have taken the steps, my lord, registered usual as well as dusty, my lord.
Then what
And
happened?
so far the dusty is concerned, I filed the affidavit today.
Very well.
My lord, the copy of affidavit is.
Okay, Mr. Brigadier submits that the affidavit of Dusty has been filed today. The same is not on record. List the matter immediately after the summer vacation, bringing on record the said Dusty service.
My lord,
Affidavit of
Lordship,
this.
kindly fix the date, my lord. Keeping in view urgency, my lord.
Okay, on
Yes.
19th of July, 19th of July, bringing on record the said affidavit of Dusty.
They filed the dusty affidavit. And
You filed?
yes,
Yes, then,
39 and 40, both matters they have filed the dusty affidavit.
Huh?
Item 39 as well as item 40.
okay, what is this matter about?
So this matter, my lords, pertain to pleadment, my lord. The pleadment was allowed.
Oh, yes, yes, Mr. Singh, where are you? He didn't want to argue when the matter was initially taken up. On the ground that Mr. Singh only knows I can't argue. I still remember a good friend of mine when I was a lawyer, whenever the judge asked him, he said, I would not say anything, my senior would only say. Yes. Tell me.
There are two separate cases going on side by side between the same parties. Landlord and tenant. During the continuation of the landlord filed an application saying that I have already sold the suit property during 2016. And this application was for the first time filed in the year 2020. That since I have sold out the entire suit property, I have lost interest, and purchaser, who happened to be one of the witness on behalf of the plaintiff, they have purchased and they should be brought on record as plaintiff. And in another suit where I have filed the suit, my lord, where I have prayed for repair of the tenanted premises which had got gutted down, my lord.
Who are the respondent number 2, 3, and 4?
They are the legal heirs of the original landlady.
And who is respondent number 1?
They all are legal heirs. Son-in-law, daughter, and granddaughter.
Nazrul Hussain is who?
Nazrul Hussain happens son of the landlady and also the power of attorney holder. Subsequently,
Who is 2, 3, and 4?
2 is son-in-law because he had married the daughter of the landlady.
And how does he have the connection with Nazrul?
Brother-in-law.
Did they give the power of attorney
they are
to
friendly.
Nazrul
Nazrul also took power of attorney from his brother-in-law subsequently. And
from
also-
Nafisa also?
Right.
Did they exhibit this document before anyway?
Yes.
That they have exhibited the power of attorney?
They submitted, my lord, before the learned trial court, and on the strength of the power of attorney, he submitted the application for substitution of the new purchaser. Saying that our name needs to be struck off and the purchaser should be brought as a plaintiff in their suit. And in the suit where I am the plaintiff, my lord, he
said on behalf of the defendant that my name as a defendant should be struck off and the purchaser should be brought in as a defendant. Now, our humble submission, my lord, is so far his suit is concerned, if he has no interest in his continuation of his suit, he can very well waive. But he cannot come and make an application that his name should be replaced and another set of plaintiffs should come in. So far my suit is concerned, my lord, I am the dominus litis. And there are, my lord, judgments also which says that it is the assignee who can approach the court under Order 22, Rule 10. It is up to the assignee. They may approach. But here the assignee has not approached the trial court.
Who has approved?
The seller, my lord. The original plaintiff or the original defendant, we can say in my suit, he is the defendant, my lord, who has sold the property and who remained silent for at least 5 years, my lord, because the property was sold in 2016 and the suit is continuing. At that period of time, my lord, one CRP was before this honorable court between the same parties. They never spoke about selling of the suit property. It continued. In 2022, they made an application saying that the property has been sold out and our name should be struck off and it should be substituted by the purchasers in their own suit and in my suit also. In their suit,
They are the plaintiff.
they are the plaintiff, my lord. They had filed the suit on twin grounds that the suit property is required bona fide for their own purpose, and also there was default in payment of rental for 1 month in the year 2009. My humble submission, my lord, is that if it is bona fide requirement or default in payment of rental, can they say in 2022 that since I have sold in 2016, new plaintiff will come and he will have the same cause of action to continue with the suit? It can't be, my lord. A new purchaser under the PP Act under Section 55, subsection 6 can claim rental from me, no doubt about that, from the date of purchase, but he is not coming before the court.
But the old purchaser has no interest in the suit.
Can abandon his suit, my lord. Nobody can force him
Then
to
what will have the impact if he abandons? The
He-
new one has to file a fresh one.
Definitely the purchaser has a right, independent right, my lord, to file a suit against me. But he has chosen to remain silent. And interesting part
And
in
your suit is what?
my suit, because during the pendency of the original suit filed by the landlady, my lord, the property got gutted down in a fire incident. And one part of the shop room, it survived. I made an application for repair and renovation. That is the suit.
Then
It is continuing. my lord.
now
Both-
you want to execute a decree against the old one
Against the old one, my lord,
who
because
has no interest.
who has no interest, but the law is quite clear, my lord. A place before lordship,
Is the judgment?
Purandar Prasad Singh judgment, my lord. The assignee, my lord, the purchaser, he can approach the court, no doubt about that. He has a right to approach the court. And it is not that he is unknown. He purchased the property knowing full well that the litigation is continuing for 2 reasons I am saying, my lord. My lord, kindly come to paragraph 6 and 7 of Purandar Prasad judgment. In order to appreciate the points involved, it would be necessary. I am reading para 6, my lord. Refer to the provisions of Order 22, Rule 3 and 4, whereof prescribed procedure in case of devolution of interest on the death of a party to a suit. Under these rules, if a party dies and right to sue survives, the court, on an application made in that behalf, is required to substitute legal representative of the deceased party for proceeding with a suit. But if such an application is not filed within the time prescribed by law, the suit shall abate so far as the deceased party is concerned. Rule 7 deals with the case of creation of an interest in a husband on marriage, and Rule 8 deals with the case of assignment on the insolvency of a plaintiff. Rule 10 provides for cases of assignment, creation, and devolution of interest during the pendency of a suit other than those referred to in the foregoing rules, and is based on the principle that the trial of a suit cannot be brought to an end merely because
the interest of a party in the subject matter of suit is devolved upon another during its pendency, but such a suit may be continued with the leave of the court by or against the person upon whom such interest has devolved. But if no such a step is taken, the suit may be continued with the original party, and the person upon whom the interest has devolved will be bound by and can have the benefit of the decree, as the case may be, unless it is shown in a properly constituted proceeding that the original party, being no longer interested in the proceeding,
But
did
Mr.
not-
Singh, if
My lord,
tomorrow,
my lord,
can you execute a decree against that person?
my lord, yes. Kindly
Because
come
here
to-
is not a case of a sale, the suit property being the title of a suit property coming into.
But he knows, my lord, about the pendency of the suit for two reasons I am
So
saying.
what is the problem in bringing him there in
My
the
lord,
suit?
kindly come to para 7. I think the answer in this judgment or in other connected judgment will be made, Your Honor. Under Rule 10 of Order 22 of the Court, when there has been a devolution of interest during the pendency of a suit, the suit may, by leave of the court, be continued by or against person upon whom such interest has devolved, and this entitles the person who has acquired an interest in the subject matter of the litigation by an assignment or creation or devolution of the interest pendent light or suit or any other person interested to apply to the court for leave to continue the suit. So assignee can approach the court for a leave, my lord. But it does not follow that it is obligatory upon them to do so. If a party does not ask for leave, he takes the obvious risk that the suit may not be properly conducted by the plaintiff on record. So far assignee is concerned, my lord. And yet, as pointed out by their lordship of judicial committee so and so, he will be bound by the result of the litigation even though he is not represented at the hearing, unless it is shown that the litigation was not properly conducted by the original party or he colluded with the adversary. It is also plain that if the person who has acquired an interest by devolution obtains leave to carry on the suit. I pause for a moment, my lord. In my case, the person who has purchased the property, he adduced evidence on behalf of the plaintiff as PW2. So he was knowing very well about the pendency of the suit. Moreover, my lord, he said
Understood. They filed an application to bring on record them. So what is the
not by
wrong?
the assignee, my lord.
So what?
But
Now they want to bring to the notice of the court that look here, now we have already sold, we are the people whom we have served. It is for the court, you see the words out there, the court may, it's not only them, the court may also proceed. We continue that by leave of the court, be continued by or against person upon whom the interest have devolved. So it may proceed because Order 22, Rule 10, the strict rigors out there, which is there in Order 22, Rule 3 and 4 is
that is not.
dispensed with.
That is not.
So it would be tomorrow, if you want to get the decree executed, here for you to get the decree executed against him. You may, if he is made a party out there, you can very well point out that there is no bona fide relief. There cannot be a bona fide. You may have a very good ground.
My lord,
How does it matter?
that is made, my lord, that may apply to my suit, but that cannot apply to the other suit where the plaintiff says that I should be replaced by a new set of plaintiff. Can he say so under what law? Because assignee can definitely come and say that the person has sold out the property to me. He is no longer interested, or even if he is continuing, I shall also join as a plaintiff.
Okay.
That is fine, my lord.
Just for example, otherwise the suit becomes useless. He may not be interested.
No, my lord, the apex court clarifies the suit doesn't become useless, my lord, at this moment of time. It is my choice. Since I am the dominus litis, I can impede them, substitute them. But since he knows very well, my lord, kindly look at the conduct since 2016. The seller knows that he has sold out. The purchaser knows that he has purchased. All are remaining silent. In 2022,
How about passing an order to the effect, interfering with this, and thereby giving the liberty to the assignee to approach, and upon approach, the court shall be at make them the plaintiff.
my lord, he doesn't need any leave. He
No,
has the
if I
option, my
give
lord.
it,
He has the
You-
option.
Mr.
But why
Mr.
we-
saying we are in 227.
Right.
27 one can do.
My lord, kindly
At,
look
at
at
the end of the day, it will be the same. He may not be interested, that is why.
I have no objection to that, my lord. But how can he dictate terms to me and say that you,
But tomorrow, if his suit is dismissed,
his suit, my lord?
his suit is dismissed, it's good, all in your favor if he is not interested.
I
You
have
still
no,
have the ground that there cannot be a bona fide requirement. Because his bona fide requirement and his bona fide requirement will be different.
Cannot be
There are
the
many
same.
judgments.
cannot be the same. And moreover, he cannot ask for
So the
default.
bona
my-
fide requirement will be different. Now, as regards that, default also would not come in. So you will have all these grounds to be taken.
my
How
lord,
does it matter?
Why to carry forward a useless suit on, imposed upon me? If the plaintiff is interested, so far he has shown interest, my lord, he can continue. But my lord, am I saying more? When I say that, where from he can come and say that you replace my name by his name?
He is only bringing to the attention of the court that look here, I have already sold this property to him. Now he is the owner. He's bringing into the attention of the court. Now, what is the duty of the court?
My lord, then the court will also look into the fact that 2016 onwards, there has been 2 CRP. This plaintiff never bothered.
That is immaterial. That is immaterial.
Can
But
we look at the other judgment, my lord? And look at the other judgment, what it says, my lord. For 2015 judgment, my lord, where Dhurandhar Prasad Singh has been referred to and relied upon.
yes,
I read para 6, my lord. Their reading of the provisions of Order 22, Rule 10 makes it clear that the legislature has not envisaged the penalty of dismissal of the suit or appeal on account of failure of the assignee to move an application for impleadment and to continue the proceeding. Thus, there cannot be dismissal of the suit or appeal. I'm reading para 6, my lord. On account of failure of assignee to file an application to continue the proceeding, it would be open to the assigner to continue the proceeding, notwithstanding the fact that he ceased to have any interest in the subject matter of dispute. He can continue the proceeding for the benefit of the assignee. Para 6, my lord.
we'll do one thing.
One more judgment before your lordship.
So, Mr. Singh, we'll do one thing. We'll have it after the vacations. We'll deem the service upon the year on the basis to be complete. And then we will have it on immediately on the vacations. Let us see. Yes, yes. In both the cases, you have filed the service, na? You got a beleg order. Pursuant to the order passed by this court on 13/5/2020, the petitioners herein have effected service by way of dusty. The service, however, to register the unusual is yet to be completed. Either as it may, taking into account the affidavit of service, this court deems that the service upon the respondent number 1 2, 3, and 4. The instant proceedings to be. This court fixes this matter again on when?
Of August, my lord, if it-
Of August 2024. On the said date, if the respondents are not represented, the instant proceedings shall proceed in their absence. Ditate বেলেগ। I said, if they don't appear, we'll proceed.
The next date, otherwise, matter is fixed on 24th.
Or
Learned file, submission of copy of the order. Trial court is also, what order is passed.
the learned trial court, the counsel appearing on behalf of the petitioner shall duly apprise the learned trial court about the pendency of the instant proceedings.
Public.
But I am the respondent, my lord, in RSA, and my lord filed a, I am, my lord, praying for my lord injunction, because my lord, after my lord filing the, my lord, RSA, the sole respondent, my lord.
You are the,
Started, my lord,
you are who? Respondent or appellant?
my lord, I am the respondent. I won the case in the lower appellate court, my lord, with the degree. Other side, my lord, prefer RSA. And having lost, my lord, they, my lord, they started, my lord, filling up the land, my lord. And now, my lord, after filing this, I started erecting, my lord, RCC pillar.
You are the plaintiff.
Yes, my lord.
You won the suit.
My lord.
Appeal was dismissed.
Earlier it was dismissed, but appellate court allow my decree. Appellate court, my lord, appellate court, my lord, allow.
So your suit has been decreed. Now again, he is there in possession.
My lord, he is in a possession and he come in appeal.
What is he constructing?
My lord, and now RCC pillar, my lord, erecting.
Huh?
RCC pillar erecting, my lord. Photocopy I could not bring because my lord, this I am, my lord, remain left to acquire price, my lord, because my lord, in paucity of time. Require, my lord, although I filed, my lord, on 6/5, my lord. In paragraph 8 and 9, my lord, I have stated, my lord. Paragraph 8 and 9.
Why? Why are you filling out?
Oh, my lord, here, my lord, the first thing, I have not received the copy of the IA as well. And secondly, my lord, very interestingly, my signature has been obtained in the notice. It is not my signature, my lord. Lordship, kindly have a look, my lord, at notice, my lord. And if this process is going on, my lord, we will.
Then,
But, if it is so much-
anyway, we will not go into those trivial aspects now for the time being. You give a copy,
Yes.
then we issue notice, let him file a reply.
But that will fix, my lord, because my lord,
He is going to fill up the earth.
No, not at all, my lord.
my lord,
Your allegation is that he is trying to fill up the earth.
he is filling up, my lord, and now, my lord, erecting RCC pillars.
That is not a part of your petition.
Exactly.
My lord, RCC pillar, I have not stated because, my lord, after filing this, my lord, because.
So
one and a
under
half
such
months-
circumstances, let him fill up the earth, make it more better. It is a highland or it is low lying.
Lowland.
So it will be good when you win the land. He shall not claim any equity. Don't worry. Okay, we'll issue notice. Notice, this is an application under Order 39, Rule 1 and 2. The Code of Civil Procedure for grant of an injunction, thereby directing the, restraining the opposite party from constructing any structure on the suit land till the disposal of the connected second appeal. Connected second appeal has been admitted.
Yes.
On 26 February.
Issue notice upon the respondent, upon the opposite party. The BJP accepts notice on behalf of the opposite party. A copy of the instant application be served upon him by Friday. Friday give the date. Right? The opposite party shall be at liberty to file reply to the instant application. List the application for further consideration. 19th of July 2024. You lost before the trial court, first appellate court.
No, in the
appellate court, I
Munsif, my
won.
lord, before the Munsif, their suit was dismissed.
No, we are not concerned. First appellate court, you
Yes.
lost.
I lost.
The appeal has been admitted.
Yes.
So you don't construct anything.
Lordship.
Don't construct.
Here, my lord,
You have already suffered a decree, Mr. Shetty. Don't construct.
no,
Till
my
the
lord,
next date.
that part I do not know, my lord, whether his allegation is true or
But therefore, I'm saying, till the next date, the parties herein shall maintain status quo as regards construction. It shall maintain status quo as regards construction, as well as filling up of the earth. In respect to the suit land, so described in the plaint of the suit.
But that part, my lord, I do not know. That is why, my lord, simply they are making the
Therefore, I'm
allegation.
saying status quo. Because you have already suffered the decree, you are on appeal. So any construction, if it is being made, it would not look proper. On one hand, this court has admitted the appeal, and you are on the other hand constructing with impunity.
Unless I file the reply, my lord, I cannot say, my lord. And I telephonically took the information, my lord. They say no, only that part which was broken by the storm, my lord, recently it was happened. That has been constructed. That's all.
So that you have,
That
storm
broken part, my lord.
Storm is long over in the month of
No,
May.
no, now it is not there, my lord.
So it's okay till the next day.
Yes.
Is it within time? First new application.
No, my lord. My lord, I pray for an adjournment, my lord. Mr. A
Why?
is to appear in this matter.
Huh?
Sir is to appear in this matter, my lord.
Hello. The counsel appearing on behalf of the applicant seeks for an accommodation matter be adjourned to be listed after the vacations. The order is written. Full hawk. Here. There's some mistake. The direction being given.
Actually, at that moment, point of time, Lordship, it was disbursed by the Assam implementation of Assam Accord Department. Right now, what is the position? I don't know, like, actually. Actually,
T.R.
not.
Gogoi.
T.R. Gogoi.
Mr. T.R. Gogoi appears on behalf of the government of Assam and seeks some accommodation for obtaining instructions. List the matter again on 22nd of July 2024. Full stop. In the meanwhile, Mr. T.R. Gogoi shall obtain the necessary instructions with the appropriate authority whom the directions ought to have been passed. Yes, Mr. Mahmood, what are you doing? This is the last of the matters. Who fixed the matter for hearing?
Code 10, Lordship. Code 10.
Huh?
Code number 10.
Oh, no, there, quote there. I don't fix matters for hearing.
Partha.
By this court.
None of the courts are kept.
Okay, this is what?
My lord, this is for my lord, delay condonation for substitution.
Yeah,
First
first
one is
time.
my lord,
Lordship, in this case, what happened, Lordship?
All this, issue notice.
3 persons died and only 5 applications are filed, Lordship. And moreover, Lordship, appellant number 3, substitution application for appellant number 3 filed. And before that, wakalatnama for
Anyway,
appellant
let the notice be issued. You are appealing for all.
correspondence, Lordship, all respondents. Lordship.
Issue notice. Miss So-and-so accepts notice on behalf of the all the
One respondent
respondents.
died, Lordship. One respondent died.
You are appearing for whom?
Other respondent, except Lordship, that respondent number 1.
No, no, no,
One
no.
died.
Are you appearing for the?
Earlier, I was appearing, Lordship.
Now, are
Now
you appearing for the newly substituted one? No.
after substitution only I can appear, Lordship.
That is where notice has to go.
Lordship.
The case is notice. Issue notice returnable on after 4 weeks. Steps be taken by way of registered as well as usual. To stop. Miss R. Chaudhary appears on behalf of
Respondent number 2 to all respondents, Lordship.
2
All
to how many?
principals, Lordship. 2 A to 2G 3, 4, 5, 6, 7.
appears on behalf of the respondent numbers 2 to
2
7.
A to 2G, Lordship.
All
All
respondents except
Lordship.
all opposite parties except opposite party numbers. Substitution is done. How many are there?
No. After
Respondent number 1.
tomorrow is legal errors.
One. How many legal aids are there?
My lord, 3.
So 1A, 1B, 1C it would be.
Lordship, whether your Lordship will issue notice in these applications as because Lordship, the applicants are not the legal heirs, Lordship. Other appellants file these applications for implement of substitution of some of the appellants, Lordship, without any wakalatnama.
Come go. List the matter on Monday, Wednesday. And liberty is given to the parties to mention the matter for and list the matter on Wednesday. Next give you on 20,
I pray, my lord.
24 26 6 2024 at 2 p.m.
Lord, may I pray, my lord, on 27 or 28, 26 of election.
What?
Day of our bar election, my lord, 20.
What are you going to do with the by-election? Stop all this election business with you.
My lord, I am one of the.
Don't.
My lord.
Ask anybody else.
Except
to appear.
26, my lord, anything.
No, no, no.
27, my lord.
26. You don't need to contest. Don't contest in elections. Stop contest.
On 27.
No. You are contesting for president. And furthermore, you should not.
On 27.
No. Okay. Rakamgura. List the matter after the vacations.
Obliged.
Yes, Mr. Mahmood. I don't take up hearing in this manner.
On Thursday, my lord.
Absolutely no. Tomorrow. No. This can't happen like this. 46, 47, 48. I'll do one thing. Not before me. Let it go to court number 10.
Right.
They mentioned the matters.
What
Na?
is the reason?
You mentioned the matter before them. How did the matters come up today?
Heard by the court number 10, part heard, Lordship.
Which one?
But item number 46 and 47, Lordship.
Part heard?
Part heard, but it is not written as part heard. The court wanted to complete the hearing today itself.
Okay, it has been brought to the notice of the.
Oh, well,
Recorded
it's not part
Lordship.
hard, how it,
As it is not reflected
Not
as part
part heard,
heard, so
not
it
part.
cannot be recorded, Lordship.
Huh?
Otherwise, Recorded lordship as.
No, no, I won't record in that manner. It has been submitted at the bar that item number, that RSA number 132 of 2018. Both are connected.
Separate lordship. Councils are also different.
तेरे बेलेग-बेलेग होता है. What is the order written? Last order written? The order लिखी थी सबसे पहले की. 47.
Many times, some
13.6 it will remain.
arguments are heard, but unless it is recorded as part heard, why you should treat it like part heard?
On request.
13.6 lordship left over. Before that 11.6.
Okay, we will have these matters. I can't fix it now. We'll have it there because I am taking the roster. With this order, I can't help you.
After vacation lordship.
These matters be listed by the put it to the beleg order. These the instant second appeal be listed for hearing immediately after the summer recess.
That may can live. That may be fixed.
Eta dibo first to dibo 6th of August. Second to dibo 8th of August. The third to dibo the unlucky 13th of August.
Our lands are under their occupation since long. Only consider this.
They're very new matters.
Hello?
They're very new matters.
No. It is since Gwalpara it is coming. By title suit, then first appeal, then second appeal.
Yes.
Actually, in first appeal, my lord, by title suit, you own the case. Only possession was not given. Landed district has said, you have declared the right title in interest of the party. Then why possession is not given? District has gave possession, only possession. Then against that they have come.
Liberty is given the parties to length at the upgrading.
Before that point.
Huh?
Before that day.
That order will be there. Based on so and so, liberty is given to the part. Mention the matter for appeal.
Long time.
Whoever wants.
We are enjoying the fruits of my land.
So you want to mention it, you can very well mention it for upgrading on that day. You don't want it, okay. Remove that.
I only want the short that may be fixed. This is my only prayer.
Do you want to come during the summer holidays? I'm free.
That means, that means.
Is holidays?
Vacation.
Vacation.
Yes, I have no objection if my learned friend agrees.
And then I'll ask the Chief Justice. A bench is to be given. You want it in the vacation court? Vacation court is there. No?
Definitely there.
You want to do it in the vacation court?
But my learned friend submitted because nobody can complain her to come on the same holiday unless she agrees.
Okay.